The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning in this magnificent courtroom. We have four interesting cases, good lawyers. Mr. Abeles.
Yes, Your Honor.
Good to have you. This was the Justin Wolf versus Dodson. And
Yes,
I
Your
have
Honor.
a recollection that Mr. Wolf's case has been here before.
A number of times, sir.
Good to have you with us, sir.
It's good to be here. Thank you. Are you ready for my argument, Your Honor? Okay.
You may proceed.
May it please the court, it's not contested in this appeal that the government chased Owen Barber, the petitioner Justin Wolf, star witness, off the stand and intimidated him into silence during its interview with him.
The government just says it doesn't matter because, for one thing, your client ultimately pled guilty, and for another thing, the most recent declaration of Mr. Barber is not new. Is that right? So,
That's right. That's right, Your Honor. That is their contention. Our argument. I'm sorry.
so what about the fact that that Mr. Wolf ultimately pled guilty?
Sure. So, the courts, we cited a number of cases saying that does not preclude us from making an actual innocence showing. I understand that the guilty plea is a factor that can be considered by the judge on the merits of the actual innocence during that inquiry, but it's not dispositive, and we have a number of arguments that we would like to present attacking that guilty plea as involuntary under both our vindictive prosecution theory and our witness intimidation theory. And so, while it's not contested that there was witness intimidation here, because this issue arrives to us under Rule 12b-6, what is contested is how to characterize evidence that is later put forward by a suppressed witness for purposes of an actual innocence inquiry. The director says that such evidence must be newly discovered. We say it must be newly available, and I think this appeal comes down to who's right on that question. Since this is a judge-made doctrine, actual innocence, and the rules come from the court in terms of new evidence, we start with Schlupp. The Schlupp case is the one that gave us this doctrine, and it did not involve newly discovered evidence. What happened in Schlupp was that there was an alibi witness. He was available to testify at trial, but Schlupp's lawyer was alleged to be ineffective. And so he did not call this witness, who was not newly discovered, but that was new evidence. That was new evidence in Schlupp. In House v. Bell, similar. There were bloodstain evidence that was available at trial, was not newly discovered, but was characterized by the Supreme Court as new evidence. It was evidence that was not presented in those cases because of a constitutional violation that's held against the state. In those cases, ineffective assistance. In this case, the evidence wasn't available also because of a constitutional violation, at least as we've alleged.
What would you have us do with the language in our third go-round on this case, Wolf 3, where we said Barber's availability was speculative?
Yes, so the standard the standard for new evidence here is whether it's reasonably available. There, what the court was looking at that time was whether it was conceivable that our client, Justin Wolf, could have a fair trial in the Commonwealth of Virginia. It's the highest standard under habeas law, and it was conceivable to the court that Barber could appear. They didn't say he would appear. They said it was conceivable and premature. That's an important point to make. It was premature to determine whether he would show up or not, and the court said it would deal with that. First, it needs to be exhausted in the state system, so it wasn't right for adjudication, and otherwise it would be dealt with on habeas here now.
And since then, hasn't Barber himself, as well as his attorney, reiterated that he would not have testified and there was no hope of immunity in sight?
Yeah, so that's in Barber's latest declaration, the April 2023 declaration, he says he would have resisted testifying to the fullest extent. Of course, he was under death threats, or veiled death threats, I'll call them, at the time. So of course he would have resisted testifying.
You're saying death threats, that the prosecutors told him they were going to subject him to the death penalty.
That's what I mean.
If he changed his story.
I'm sorry, Your Honor, could you say that again?
If he changed his story, if he
Right, yes, Your Honor.
If he repudiated his earlier testimony when Wolf was convicted.
Yes.
That Wolf hired him.
Correct, Your Honor.
There's no question that Barber's the trigger man. He's been consistent on that. I'm the trigger man.
Correct.
The question has been whether Wolf is in on it with him.
That is the question, right. And during Wolf's first trial, that's the one that this court ended up throwing out eventually. Barber testified against Wolf. He was the star witness. And after this court upheld the habeas ruling in Wolf's favor, the very next day after the mandate came down, that's when they visited Barber in prison. And that's when they started reading Supreme Court cases
The very
about...
next day of which case was that? Was that
So this is September 10th.
our second case or third case?
So the first case is in 2009. That's just a case about whether he should get a hearing for actual innocence, and the court said yes. The second case is the one that we're talking about here, Your Honor, where the court affirmed the grant of habeas relief to Mr. Wolf.
Is that 2012?
September 10th, 2012, the mandate came down.
He affirmed Judge Jackson.
That's exactly right, Your Honor, yes. And it was a very strong opinion. It was very embarrassing to the Commonwealth, which was really lambasted by this court, and they then took it out on Barber and Wolf. Those are our allegations. They began a retaliation campaign.
That's when they had that interview with him that they recorded surreptitiously.
Yeah, they recorded their own witness intimidation, yes.
Right, so it's not an allegation, there's a recording of it.
That's right. That's right, Your Honor. Yes. And so in both of those cases, getting back to Schlupp and Bell, the evidence wasn't presented there because of constitutional violations, ineffective assistance. Here, it wasn't presented or available also because of constitutional violations that we've been talking about. Now, coming back to this issue of what's the standard, newly discovered or newly available.
But you're trying to, the guilty plea was in 2015.
That's right, Your Honor.
It was after all this, and he pled guilty to murder. Now
Yeah.
you've got to upend the guilty plea in this proceeding.
There's, yes, so there's a guilty plea in this proceeding. I think it was 2016, actually.
And Wolf stood up and was put under oath and said, "I did it." And you're saying that Wolf lied to the court when he said, "I'm guilty of murder."
I have to, that's a matter of logic, yes, Your Honor. Yeah,
That's exactly your position here today.
And he submitted a letter, did he not, actually in addition to the plea, he submitted a letter?
There was a letter that was submitted with the plea, yes, that the state says was not required. If there's a hearing here, we're going to show that it was, that he was forced to write that letter in order to in order to get his guilty plea approved. But
That
what
was to get out from under the death penalty.
he was
That's
scared.
That's your theory. He had to do it, plead this way to get out from under the death penalty.
Yeah, he had already
And
been.
also the 6 additional charges they piled on him after the Commonwealth lost the first time.
Yeah, and remember, he had already been sentenced to death once. And so he had a very, very reasonable fear that he was going to be put to death again. And I understand the concern about not being truthful with the court. Of course, I understand that. But what we would say is that when it comes to vindictive prosecution, that's the whole point of a vindictive prosecution, to get a guilty plea when you otherwise wouldn't deserve one. It overcomes the will of the defendant. That's what vindictive prosecution means, and that's what happens here, and that's why he submitted those letters, Your Honor.
What about the district court's concern about Barber's credibility?
So obviously that kind of thing is going to arise in a case, in a murder case. But what I would remind you is that Barber's testimony is corroborated. Okay, we submitted additional evidence with our testimony, with Barber's testimony, that from his cellmate, so contemporaneously he had said, no, it was just me, it wasn't Wolf. From his roommate, the guy he lived with, so not a person in jail, he said the same thing. And we had a private investigator at the time who verified.
Didn't he testify at some hearing before Judge Jackson?
That's my next point. His testimony was already deemed credible.
He gave the exculpatory story, right?
Exactly. Yes, Your Honor.
I did it myself. Wolf was not involved.
Yeah, and
And Judge Jackson specifically found that he was credible.
Specifically found him credible and persuasive at a hearing, and Judge Jackson cross-examined Barber at that hearing. So he asked the questions he needed to get asked, and again, that's after a hearing. This time there was no hearing, and there were these comments about reliability. And yes, he's gone back and forth a couple of times, but his exculpatory testimony, which is against Barber's interests, by the way, he has no dog in this fight. All he has is risks, because the state has never, now it's been a long time, of course, but the state has never lifted its threats against him, that if he came forward in these cases on Wolf's behalf, he'd be retried, and using his confessions against him. So I think, the court is, I'm going to save three minutes for rebuttal, which is what I have left here. But, I think the court gets it. This evidence was not available when Wolf pled guilty. It just wasn't. Not voluntary, not on a compelled basis. It later became available, and if there are questions about credibility, let's have everybody into court again, and let's figure out who's being honest and who's telling the truth here. But we just deserve a chance to make our actual innocence case, because our case really is very strong. Thank you. Oh, I'm sorry.
Yeah, I actually wanted to ask, it seems that there's a lot of overlap between Barber's declaration in 2005 and the 2023 declaration, so what exactly are you alleging is specifically new there?
So our argument, so I understand your comment, Judge Berner. Our argument is that testimony simply was not available at the time of trial or plea. It's new because it became newly available.
At what time? You said the time of trial.
At the time he pled guilty. At the time Wolf pled guilty,
There was no trial, there was a guilty plea.
Yeah,
You're talking about
exactly.
2015.
Yes, Your Honor. And so I understand your
You're
point.
saying the 2005 information wasn't available in 2015?
Barber was not available to testify as an exculpatory witness in 2015 when Wolf pled guilty. What changed at habeas is he is available and he's offering his exculpatory testimony.
Because that was still the time when he was saying, I will take the fifth. I'm not going.
Yes, he had done that twice already in
there
federal
was
court
no-
and state court. He had done that twice already.
And there was no offer of immunity, at least nothing on the record.
Never, and I think we showed in our briefs that state law, under Virginia state law, you
There's
can't
that.
compel a witness in this circumstance over his good faith Fifth Amendment objection. They never responded to that, but we showed that. Because Virginia law only permits use immunity, not derivative use immunity, so Barber could not have been fully protected if he was compelled to testify.
Are you saying then that our discussion of that point in the 2013 opinion was erroneous?
I think it was not as precise as it could have been. Yeah,
trying to be-
that's what I would say.
You're trying to be gracious there, but,
Yes, well, yes.
but
That's good.
we said he couldn't get immunity. You don't know it till you have a trial.
You were talking in terms of
You put
theoretical.
him on the witness stand and see if they can get
It
him
was,
to,
it was theoretically
see if you can get
possible.
him to talk.
Yeah, it was theoretically possible that his lawyer could have asked Barber to agree to a bad deal that wouldn't have immunized him. So you
But
were
you
right.
just said
It
you
was
could get-
theoretically
you-
possible.
You just said you can get use immunity.
Yeah, but that would have been, that would not have been any good for Barber.
That wouldn't have been enough?
He was
Well,
worried
you get
about.
use that's all you can get in the federal court system.
Yeah,
That's all you can get, and the Supreme Court has said that's enough immunity to make somebody talk.
Well, so the law in Virginia is when compelled, the witness must be fully protected. Use immunity for Barber would not have done him any good. He was worried about being tried for perjury based on his prior testimony
But there-
at habeas.
But you can compel somebody to testify with use immunity.
So I understand your point, Your Honor, but I think we cited cases from the Virginia Supreme Court that are to the
But it
contrary
sounds
of
to
what
me
you.
like Virginia law is the same as federal law.
Under Virginia law, a Fifth Amendment invocation is respected, even under an offer of use immunity, if that use immunity would not fully protect the testifier. That's the standard.
Judge Thacker may have something.
No, I didn't have anything else.
Any more questions, Your Honors?
You've reserved some time.
Okay, thank you.
Yep. We'll get you back up here. Mr. Curry. Good to have you with us, Mr. Curry.
It's a pleasure to be here. Good morning, Your Honors. May it please the Court, Liam Curry on behalf of the appellee in this matter. If I may, I know we've just heard a lot of arguments that seemingly relate to the underlying merits of the habeas claims that were raised in Mr. Wolf's amended petition. But the issue on appeal concerns the two questions that were resolved in the district court concerning what constitutes new, reliable evidence of actual innocence. First, this court is tasked with determining what standard should apply. And then in the district court, the two standards that were being considered was evidence that was either newly discovered or evidence that was considered newly presented. It is our position here in this court today that no matter what standard is applied to Mr. Barber's 2023 declarations, they are not new for the purposes of establishing actual innocence through the Schlup gateway. And so I would disagree with my opposing counsel's contention during his own argument.
Barber's testimony wasn't available to Mr. Wolf back in 2015, was it?
Your Honor, my answer to that would be it's purely speculative. The availability of Mr. Barber's testimony would depend on whether he is called as a witness at trial.
Well, based on his declaration, he he himself says, and he's repeatedly said, that he would have taken the fifth. In fact, he had taken the fifth before, and his attorney says there was no hope or offer of immunity forthcoming, was there? And where, if there was, where is that in the record?
I don't think there is anything in the record to that
Okay.
point, Your Honor, but to address this question
But
about.
that's uncontradicted.
Can you repeat the question?
He said, well,
That there's nothing in the record about,
That the government offered immunity.
that's correct, Your Honor.
Right, so there was no immunity available, so he was going to take the fifth. That is what, at least they argue, makes this new declaration, new.
Well, I think the problem with that argument is that this newly available standard, as far as I'm understanding it, does not exist. In the case law that I have seen
Yeah.
that talks about evidence that is newly available, it talks about evidence that had not been discovered at trial and therefore was not available for the witness or for the defendant to put before the court. And that is not the that is considered a tougher standard, right? Because they have to show that they had made some efforts and that they were unable to discover this evidence and put it before the court. The lesser standard is newly presented. And that, under that standard, anything that constitutes new reliable evidence can come in as long as it was not presented to the finder of fact. Now, the district court found that that was a distinction without a difference under the specific facts of this case, because the evidence of actual innocence was not new under any reasonable definition of the term. If I could turn the court's attention to Barber's 2023 declaration, because I think it bears repeating to the panel that the task today is to determine whether there is evidence of factual innocence sufficient to undermine confidence in the convictions that Mr. Wolf currently has.
Right,
Which are
and
coming-
so Mr. Barber saying he didn't do it is evidence that, arguably evidence that would have turned the tide.
Well, their position is that it is reliable evidence of that.
Oh,
but
it's not just their position, the district court found him credible.
the district court found him credible under a different universe of facts. And I think that.
Why does that matter?
we're talking about Judge Jackson's ruling that he was credible.
Right, and I want to emphasize that I feel like we're conflating the reliability.
His testimony at that point is consistent. His testimony before Judge Jackson was consistent with the declaration of 2023
That is correct.
on the crucial point of whether Wolf was involved in the murder.
That is correct, Your Honor, and that is relevant to the district
In
court.
both of them, the witness, Barber, says, I was the trigger man. I did it. Isn't that right? I was the trigger man, which is different, though, that he testified at the trial that Wolf was involved. So he repudiated before Judge Jackson, and he repudiated in this declaration what he had said at the trial. He's exculpated Wolf.
No, I understand, and that is a point that they are making in support of the reliability evidence.
If his testimony in this declaration and before Judge Jackson is true, then Wolf is innocent.
If it is true, yes.
If it is true, and Judge Jackson credited it, the district judge.
What Judge Jackson was concerned about was whether he was presented with credible testimony that, if true, would undermine the capital murder conviction based on murder for hire, because Barber was the key witness to supply that testimony for the convictions that were being
At the
reviewed
trial.
at the time of Judge Jackson's ruling. We are in a different factual universe right now. Those
Why?
convictions.
Why? You've said that a couple of times now. I don't understand why.
Because those convictions have been vacated, Your Honor. He requested that relief and received it. No testimony of Barber was relied upon or even necessary for the convictions that he is challenging here. So the task is not.
Because he pled guilty.
Because he pled guilty, Your Honor, because he presented a proffered and agreed statement of facts as to the true version of events. because he wrote a written confession detailing his own obligations, or his own responsibility for the death. And I know an argument has been presented that this was some sort of obligation of the plea agreement, but we can read the written confession itself to cast aside that notion. It says, "My attorneys asked me to write a statement about my involvement."
Yeah, but opposing counsel's saying that if they if they had an evidentiary hearing, they would present evidence that also was coerced by the government, as they've coerced everything in this case from the inception.
Well, I mean, I think there's a point that I've been trying to make about.
It's not contested that there was witness intimidation here, is it?
It's absolutely contested. I mean, that'll be the factual basis of a hearing if
I've
he overcomes
listened
the
to the audio of the interview. Have you listened to it?
I have read the transcript. I
No,
don't know.
listen to it.
I don't know. I don't think I have. No, I have not listened to the transcript. Oh, I'm sorry. I have not listened to the audio at this point because I think it's premature. We're dealing with the question of passing through the Schloop actual innocence gateway. And one point I've been trying to make is that there are questions about reliability, but
Right,
Schloop-
but doesn't witness intimidation go to reliability? I know you're gonna argue, or I expect you're gonna argue that he can't be reliable because he changes his story so many times, but I think opposing counsel would argue that he changes his story so many times because of the intimidation by the government.
No, Your Honor, the point that I'm trying to make is that it's not new. When they're making the argument that it's reliable because Barber has presented this testimony in the past and it has been found to be credible, all of that occurred prior to the guilty plea. It is still a requirement of Schloop that
Right, and then this goes back to them saying it's his availability that is new, and your argument there is that that's not a thing,
We're not looking about.
availability.
We're not looking at availability. We're not looking about admissibility of any of this evidence. This is about him building a record of new evidence of his actual innocence. Right? The Schloop standard is intentionally high. It needs to be, I'll read to the court some of the language that the cases often use. It requires, it's a confined category limited to certain exceptional cases that involve a compelling claim of actual innocence. Such claims are extremely rare and would require showing based on the totality of the evidence that it would prevent any reasonable juror from finding him guilty. And so if we can set aside the reliability aspect, this evidence has to be new. And there are a number of definitions about what new can be, and that is part of this court's role in preserving, in addressing this appeal. But the lowest standard that I can imagine, the lowest hurdle that he can clear is to just show that the substance of the actual innocence claims that Barber has presented were not presented to the trier of fact. And that is just not the case. At the guilty plea hearing, both parties agreed to a proffered set of facts. The proffered set of facts included the fact that Barber has recanted his testimony. There was a detailed airing of the facts that gave the trial court, who was sitting as the finder of fact, the ability to assess whether Barber, whether it should accept the findings of guilt that are being, the evidence of guilt that's being presented in light of the fact that Barber had recanted. All of that was put before the trial of court. And the trier of fact had no problem entering a finding of guilt based on Wolf's statements that his pleas were voluntary, based on his statements that he had admitted that the proffer of facts was true and accurate, based on this letter that he wrote on his own volition. As he says in the letter, it's not addressed to the court, it's addressed to the victim's family. And he says, saying I'm sorry, it says, quote, "Maybe it seems easy for me to say I'm sorry, but it's actually the hardest thing I've ever done because I have to admit what I did which contradicts what I said at trial and the position that I've taken on all of my appeals, which I think includes all of the habeas litigation. He says, but I want you to know the truth, and that's why I am writing this. So that is part of the factual innocence calculus that the court has to consider. The court needs to consider the fact that he's confessed in a detailed way. It's not a partial confession. It is a total confession to his involvement. The court has to consider his guilty plea. The court has to consider the proffered statement of facts. And the court, I think, has to consider as a threshold matter that because the proffer detailed extensively Barber's vacillations, I believe is the word that the district court did, in terms of what his version of the story was, that is all part of the analysis. And the district court found, look, it may have seemed reliable in 2013 or in 2012, that Barber's account, but in light of the fact that there's been a confession, a total confession, a guilty plea, and a proffer, nothing there is new. It's not new under any
But can the
definition.
district court make a determination of credibility without having conducted an evidentiary hearing?
Well, I think what the court, what it said was that based on the fact that Barber has told so many different sides of the story, that this, I think it was kind of weighing it against the facts of the case as I was just describing. The fact that there's been like a paradigm shift in light of the guilty plea. Because when we have...
Right, but normally we defer to a district court's credibility finding because the district court has the witness in front of her and can assess credibility based on demeanor and other factors that are in front of the court. Here, the credibility determination, if you can call it that, was based on paper that is in front of us as well on appeal.
Well, it's my understanding of the record that there was, if the court takes any issue with the fact that a determination of credibility was made based on the fact that Barber, based on the fact that he's told many versions of the story, the district court...
He told many versions of the story?
I'm sorry?
I thought there was only two versions of the story. And in one of them,
Well-
and the only two versions of the story that Barber told, and part of it was always consistent. It was always consistent that he pulled the trigger, correct?
Yes.
And the only thing that varied was whether Wolf was involved.
That's correct, Your Honor.
And he testified at Wolf's trial that Wolf was involved. And he had repudiated that before Judge Jackson, when Judge Jackson saw him and listened to him and said he's credible.
Right.
And that's what he says in the 2023 declaration. Wolf was not involved. But he didn't deny his own involvement. So you say many versions.
Right.
There's really only two versions.
No,
And half, 50% of that is consistent.
I perhaps spoke inartfully, Your Honor. I wasn't trying to convince this panel that he's told more than two versions. I was simply referencing the fact that...
You said many versions. He told many versions. And Judge Berner pointed out, he apparently didn't testify at all in the state court proceedings in 2015.
No, there was no trial in 2015 or 2016.
There was no, he didn't testify. He testified live before Judge Jackson, where he got relief, where Wolf got relief.
No, Your Honor, I did not intend to mislead the panel into believing that he had told more than two versions. I was simply referring to the fact that he has vacillated back and forth between the two, beginning in 2005.
Well, he's vacillated back and forth. He's been consistent between 2005 and now. 2023, he says, Wolf,
Well, after
not
2005,
involved.
Right, had nothing to do with the killing. That's what he says.
after 2005, I believe he drafted an affidavit in which he repudiated his recantation, and then he swore out new affidavits And then prior to.
That was because, as he says in his declaration in 2023, that he felt he had to choose between falsely testifying against Wolf or dying, because he was threatened with the death penalty.
Well, no, I understand that that is his position, Your Honor, but the fact of
Was he
the,
threatened with the death penalty?
he was reminded of the terms of his agreement.
Was that
I'm
part of
talking
his-
about Barber. Was Barber threatened with the death penalty?
Your Honor,
You said you read the transcript of that. Did they tell him if he didn't stick to his story that the death penalty would be back on the table?
that is my recollection, as it would be consistent with what he had agreed to do. But, Your Honor, the point that I'm trying to make here is about new. And when we're talking about he needs new allegations of factual innocence, not new allegations of misconduct during his trial. And of course, so what we need is something new. I think that the Schlup standard contemplates like a hypothetical situation. The fact finder has adjudicated him guilty based on the facts that were presented. To prevail on Schlup, he must present that theoretical fact finder with new facts, reliable facts of his actual innocence.
Well, he doesn't need new allegations, he needs new evidence. Your allegations can be the same, the evidence to support your allegations might be different. And what he's saying is that this evidence to support his allegation of innocence is new because now it's newly available.
Well, I've already presented the arguments that there is no newly available standard. It is about whether this was something that was presented to the fact finder or not. The substance of his actual innocence allegations is that Barber has recanted his trial testimony. That was known to him in 2016. If we look at the 2023 declaration, the events, when the final section, which contains the actual innocence allegations, he says, you can just read my former affidavits and my trial testimony. So in his own words, he's saying, I'm not presenting anything new here in terms of actual innocence. My story is what it was in 2010 and 2005. So the Schlup standard is trying to contemplate something that is new, that would upset the balance, not of his trial in 2002, but the balance of the guilty plea. And there's nothing new. This was presented, the things that he's talking about, the substance of his statements in 2005 and in 2010, that was undeniably presented to the state court, to the finder of fact. So it's not even a hypothetical situation. We don't have to wonder whether the fact that Barber believes that Wolf wasn't involved, we don't need to wonder about how that would have affected a theoretical fact finder. It went to the actual fact finder. The fact finder was not convinced by it. The fact finder was convinced by Wolf's own sworn statements under oath, his confession that they voluntarily drafted, voluntarily submitted to the court, and had it admitted as defense exhibit 2. That's how strongly they believed in presenting that true factual record to the finder of fact. I see my time is up. I'll gladly answer any other questions of the panel. Otherwise, I'd ask the court to affirm the district court's ruling.
Thank you very much, sir.
Thank you.
Mr. Abelish?
Thank you, Your Honor. So there was some question presented by counsel for the state here that, you know, what is Mr. Abelish talking about with this newly available standard? So I'm quoting from page 8 of our opening brief, Royal v. Taylor, one of this court's cases, which itself is quoting Schlup. It says, under Schlup, a gateway innocence claim should be evaluated, quote, in light of all available evidence, including that considered unavailable or excluded at trial, and any evidence that became available only after trial. A gateway innocence claim should be evaluated, quote, in light of all available evidence, including that considered unavailable or excluded at trial, and any evidence that became available only after trial. That's why we're citing this standard. That's the basis. And counsel here said it was purely speculative as to whether it was available. Well, you don't even have to look at anything else. That means it wasn't reasonably available. If I tell you, yes, what's your calendar? Well, it's purely speculative whether I'm available in May, Your Honors. That's different than saying I'm reasonably available in May.
Well, and far different than pleading the fifth, right? I mean, that's in your favor that he was pleading the fifth, he wasn't available at all.
Yes, exactly.
But
Yes.
what about Mr. Curry's point that at the end of the 2023 declaration, Barbara says something to the effect of, just read my former affidavits and trial testimony?
Yeah, so again, so if the testimony needs to be newly discovered, it didn't exist in the universe before habeas, then that's going to work out well for this team. We cannot come in here and say, we never heard of this testimony until 2023. That's not true, okay? So, yes. So, first of all, that's not all he says. He does spell out the story, what happened, that Justin is innocent. But, yes, he does summarize and attach all his prior declarations, I think, I'm going to have to talk to his attorney, but I think for efficiency. That's all.
And for reasons of, I would argue, if I was his attorney, credibility and
Yes.
reliability. I've said this consistently since 2005. For the last 20 years, I've been saying this.
Thank you. I
But then
agree.
that makes it, maybe, then that goes back to his argument that then it's not new.
Yes, but we have different
So-
definitions, and that's what will be decided here as to what new means. But I think if you look at Schloop, Royal v. Taylor, House v. Bell, you'll come to agree with me. Thank you, Your Honors. Oh, do you have any further questions?
I don't.
Thank you very much.
Thanks.
Good to have you with us. We're going to come down and greet counsel and then go to the next case. In our second case, Celeste versus Lohr, Mr. Bader,
Good morning, Your Honor.
good to have you, sir.
Thank you. It's a pleasure to be here. May it please the court, Stephen Bader here on behalf of the appellant. This is a qualified immunity case where an officer on foot fired 2 shots at a vehicle as the vehicle drove toward the officer and past the officer. The 2 shots at issue in this case are akin to the first volley
And
of
past
shots.
the officer. Did you say and past the officer?
I did, Your Honor.
Right, so based on our Waterman case, then those shots were a violation.
I think that's really where the disagreement in this case lies. Our position when this court, in looking at the discussion in Waterman, is that you had several officers that were somewhere between 16 to 72 feet away from the vehicle. That vehicle was coming towards the officers, but was not necessarily in the officer's direct path. And this court in Waterman goes out of its way to discuss that. There's about a 6-second period of time between when the vehicle lurches towards and comes at the officers, and the officers begin firing. They then scramble up and fire what this court describes as a second volley of shots as the vehicle is driving away. What this court talked about in Waterman was that for this first volley of shots, where this vehicle is coming towards the officers, that even though the officers are not in the vehicle's direct path, their relation to the vehicle's projected path is critical because they were close enough where they could have been run over, I think this court says, in about 1 second, had the vehicle simply changed directions. And that is what the facts in this case show.
Well, that's not what the district court found.
I'm not sure I agree with that, Judge
The district
Thacker.
court said at JA 1379, taking the facts in the light most favorable to the plaintiff, Officer Lohr appears to have been alongside plaintiff's car and out of the car's trajectory.
He was alongside the car, and there's no dispute about that. Part of that becomes an argument about what exactly trajectory means, but I would state that the way the district court viewed this facts in the light most favorable to Mr. Caliste is that Officer Lohr was out of his vehicle, walking towards the passenger side of a vehicle driven by somebody named Tanya Cox, who is a TSA employee who had stopped as she was exiting the secured parking area. As Officer Lohr is on foot, the district court writes that he and the other vehicle were, quote, directly in the path of Caliste as Caliste exited. And that's the JA.
As who writes? Officer Lohr?
Correct. That's
We
a-
don't care what, I mean, at this point, the district court has found facts. And the district court has said Officer Lohr was out of the car's trajectory. But you say it depends on how you define trajectory.
Well, the district court is not finding facts so much as it's taking the facts in the light most favorable to the plaintiff.
And we have to, don't we review, assess this thing based on the facts recited by the district court?
Yes, Your Honor, and the record evidence in total. And what,
Then why are you talking about what appellant says the facts are versus what the district court has found that the facts are?
I don't believe that I am. What I was referring to was the district court's description of the evidence at JA 1369, saying as Officer Lohr was on foot approaching Ms. Cox's vehicle, he was directly in the path of Caliste. That's at JA 1369. And then the district court writes that Caliste approached and narrowly passed Lohr, and Lohr then
Oh,
shouts.
so that, you're talking about at the initial encounter before he shot at him,
Right.
right?
Right.
And then the district court says as he passed him.
Right, and that's really where
And that's where we go back to Waterman.
I think that's correct.
Okay.
I think that's correct. And that's really where what Waterman talks about is not so much that that an officer is in a vehicle's direct path, but that the officer is in such a position where the vehicle presents a risk of deadly harm because they are close enough where the vehicle could move and come and strike them. And the facts in this case, where they most match up to the first
How
volume.
was this, okay, go ahead.
Well, where they most match up with that first volley in Waterman is that there's no change in circumstances. What you have is a fairly rapid series of events here that occurs over the course of a couple seconds, and the vehicle's trajectory is consistent in the sense that it's always moving forward. It's not one of these cases where the vehicle stops, backs up, and moves in different directions, as we've seen in some of these other courts' decisions. This is a case where the vehicle continues effectively on the same path. The district court, in describing the facts, notes that there's about 2 seconds between when Officer Lohr shouts, "Get out of the car," and the shots are fired. And in Officer Lohr's description of that, it's really a product of time and space that explains why the shots were fired when the vehicle was next to him, as opposed to the vehicle had passed such that the threat had dissipated. And that's really what the Waterman decision talks about, is that if these officers are in a position where the vehicle presents a threat because it can turn and strike them in about 1 second.
But this vehicle was past him. He was alongside it and it had out of the trajectory of the vehicle, according to the district court. So how was it gonna turn and strike him?
I'm not sure I can answer, as a matter of fact, how he could turn and strike him, but what I would say is that Waterman talks about the fact that this closeness to the vehicle, this proximity, is a factor that would go into how a reasonable officer would perceive the threat.
But it
And-
seems to me that you're over and over again, you're disputing the facts, and we've said repeatedly that where summary judgment is denied as to particular claims solely because there's a genuine issue of material fact, we lack jurisdiction to consider it. So how do we have jurisdiction to even consider your claim?
Judge Berner, we're not disputing the facts. All the facts here are taken in the light most favorable to the plaintiff as set forth in the district court's order.
So what's the question of law?
The question of law is whether Officer Lohr's response to this was objectively reasonable when looking at this court's jurisprudence on the first prong of qualified immunity, which would be whether an officer would have reason, or a reasonable officer in this officer's shoes would have reason to believe that they were faced with a deadly threat. Here we would argue a vehicle, which is this court and the Supreme Court has recognized can present a deadly threat, coming at him so close and so near to him that he didn't have
Well,
time.
the vehicle had come close and near, and then it went past him.
And-
Those are the facts as they are presented to us and that we have to accept as true. And so what you're saying is that we should find, as a matter of law, not fact, that at that point, the officer would have maintained a fear for his life at that point.
Correct, and I would note that that is the exact analysis, issue, and outcome in Waterman as to the first volley of shots. Of course, the second issue in these cases is whether they're
But in Waterman, the first volley of shots, the car was coming at the officer.
Correct.
And then the second volley was when it was past the officer, and that's where there was a use of excessive force.
Right.
What's the difference? I mean, the office, here, the car was past the officer, and he shot at the car. What's the difference?
I think the difference is degree. In Waterman, what the opinion discusses is not just that the front bumper had passed the officer's position, it's that the officers had got out of the way, they scrambled up, and then they continued to fire as the vehicle passed on. Here, you're almost in an intermediate area where the vehicle is coming at the officer, and what the officer testified to and what's shown on the body camera
Well, you
footage
keep
is...
saying it was coming at the officer, but it had passed,
Well, before...
and he was out of the trajectory. That's what we can't get
Well,
past here.
and I want to, what I'm referring to is that this, you know,
How he
2-second...
felt, or why he would have felt reasonably threatened,
Right.
is what you're trying to get at.
Right, I mean, there's no dispute that the vehicle was coming at him. I mean, the district court finds that, that's what all the witnesses testified to.
Just not when he shot.
Right, that's,
And also not going 25 to 30 miles per hour, as your brief and his testimony said. Where else is there anything in the record that the vehicle was going 25 to 30 miles per hour, other than the officer's own testimony?
that's the officer's testimony. All I can say about that is I think when the court...
So I'm sure he charged him with speeding or reckless driving or something like that then, did they?
Well, just to respond to that question, I do believe he was charged with several things stemming from this event. I believe all those charges were dismissed. But just to make sure I'm tracking with Your Honor's concern, that's the officer's testimony. When the court watches the body camera footage, he's probably not going that fast. I'm not going to comment on that one way or the other because I don't think that's material. I think what's material...
Well, you put it in your brief.
That's what he testified to.
Okay, so I assume you thought it was material.
Well, I think what's material is that he's coming at the officer with such speed that the officer was not able to react, or that the officer's description of why the shots hit the side of the vehicle was a product of his reaction time and how quick the vehicle came at him, and that is shown on the body camera footage. But to hit the second prong, the clearly established right prong, how the district court framed this is that under Williams versus Strickland, which was decided in 2019, the court wrote, the Williams dictates that after the Fourth Circuit decided Waterman in 2005, where an officer fires into a vehicle once they are no longer in the car's trajectory, they violate a clearly established Fourth Amendment right. And I think that analysis does require some discussion. Waterman doesn't use the term trajectory. That term doesn't appear anywhere in the opinion. Williams, the court said, we've got disputed facts here how this shooting occurred. It could have happened one of three ways. Either the vehicle was coming at Officer Strickland, either it had passed Officer Strickland, either it was passing or it had passed Officer Strickland. It said because of those facts, we have to assume that those disputes would be resolved in favor of the officer being outside of the car's trajectory, and that's the term that this court used in Williams. But Waterman goes out of its way to say that trajectory doesn't mean direct path. And the way the district court analyzed this issue, it wrote that because Officer Lohr testified, or it cited his testimony at JA 1381, where he said that the vehicle was driving toward me, and then when my shot went off, it was beside me. So at that point in time, it was coming by, that's when the shots went off.
Does the police department's own investigation of this shooting have any impact on this case?
I would argue that it does not. I know the court knows how that came out, and certainly departments can internally handle these situations how they see fit, but that would not change whether this gives rise to a constitutional violation, or whether that right is clearly established. And I think that's really where the clearly established right argument is kind of fine-tuned, because if officers are trained under Waterman, they would be trained to understand that if you have a vehicle that is coming towards you, even if you are not in the vehicle's direct path, if you are in such a position where you could be run over if the vehicle would swerve toward you in a short amount of time, then lethal force may be warranted. That's the takeaway from Waterman with the first shots. An officer trained under that opinion wouldn't be under the belief that if a vehicle is coming at you, but they're coming so quickly that you're not going to be able to get your shot off in time until the vehicle is next to you as opposed to in front of you, then that driver would have a clearly established right to be free from lethal force. I would argue that that's the kind of armchair quarterbacking that this court has said really cannot be performed in these qualified immunity cases. You're talking about seconds. You're talking about an officer in the field who doesn't necessarily know what this driver's intent is when he's in a secured airport
Well,
parking.
then that argument sort of makes the police department's investigation and result there have an impact here, because that's not so much a armchair quarterbacking. That was his fellow officers, the police department looking at it and finding that his use of deadly force was not justified. That's not armchair quarterbacking. They're part of his own team.
That is the outcome, Judge Thacker, but what I would argue to this court is that the department's own internal disciplinary procedures, its finding, its determinations, those kind of internal determinations don't dictate the clearly established right prong. I mean, this court makes those determinations. That's not a decision that's made internally by departments. If departments want to do that, that is certainly their prerogative, but that would not dictate the outcome in this case. We would ask that this court reverse summary judgment. Officer Lohr should be entitled to qualified immunity under the facts viewed in the light most favorable to Mr. Kalist. And I'll reserve the remainder of my time for rebuttal. Thank you.
Thank you very much, Mr. Bader. Mr. Chu? Good to have you with us, sir.
Thank you so much, Judge King. Good morning, Your Honors, and may it please the court, Greg Sway on behalf of Appellee Xavier Kalist. Throughout this appeal, Officer Lohr has repeatedly tried to contradict the district court's construction of the facts. That violates the jurisdictional limits of this interlocutory appeal, and it contradicts Lohr's own admission below that he was not in the path of Mr. Kalist's vehicle.
So should we just dismiss it for lack of jurisdiction?
You could do that, Your Honor. We noted that in our brief. We think Lohr's arguments are so fact-dependent that he really doesn't raise, as you pointed out, Judge Berner, any question of law that this court has jurisdiction to review. But this court could also simply refuse to accept any of his factual arguments, take the facts as the district court construed them, and we think if you do that, this case is quite clearly controlled by the Waterman line of cases. That's the first point I wanted to make today, that Waterman clearly established the law here, that officers cannot shoot at a moving vehicle if they are not in the vehicle's trajectory. And Judge Thacker, as you noted, the district court's factual findings line up perfectly with that rule. The district court said in exactly those words that Officer Lohr was alongside the car and, quote, out of the car's trajectory when he fired. That really makes this an open and shut case. And this court has been...
But on this kind of a ruling, the court's really not making factual findings, it's making a factual recitation.
You're exactly right, Judge King, and I apologize if I misspoke. The point is that the district court here concluded that a reasonable jury could find that Officer Lohr was out of the car's trajectory. And in this interlocutory appeal, the court is bound to accept the facts that the district court concluded a reasonable jury could find. As I was saying, this court has been consistent in how it describes the rule. I heard my friend on the other side say that the Waterman case doesn't use the word trajectory, but Waterman quite clearly talks about the exact same guidance that this court has then applied consistently in cases like Crine, that was in 2014, before the conduct at issue here, and in Williams, which addresses facts that opposing counsel has never tried to distinguish. The district court notes that in its opinion, that before the district court, Officer Lohr offered no argument that the facts of Williams can be distinguished from the facts in this case. And in Williams, the court was applying the same body of clearly established law, that's Waterman, as well as cases subsequent to Waterman, but before the conduct at issue here, like Crine, like Lee, and concluded that a reasonable jury could find that the facts line up perfectly with the facts of those cases. So
But
that's
Williams
the
was
first.
decided after the facts at issue here.
Say it again. I apologize. Your Honor.
Williams was decided subsequently.
It was, Your Honor. It was decided in 2019, but the conduct at issue in Williams occurred in 2012. And Williams was a qualified immunity decision, which means that the court was asking, at the time of the shooting in 2012, was the law clearly established? And this court said at page 770 of Williams, in light of Waterman, there can be no question that the right Williams seeks to vindicate was clearly established on the day he was shot, so 6 years before the conduct at issue here. This case is actually even easier on the clearly established prong because, again, you have cases decided subsequent to 2012 consistent with Waterman, like Crine, and you also have, as Your Honors pointed out, the police department's own review of the evidence in this case under the policies governing the use of force by this officer that were issued in 2016, so 2 years before the conduct at issue in this case. And Lohr's own police department concluded that he didn't face an imminent danger and that he wasn't justified in using deadly force. And it disciplined him for violating the policies that were promulgated 2 years before the conduct at issue here. I heard my friend on the other side say that that discipline has no relevance here, and that's just incorrect, because that is evidence.
Is that admissible evidence?
We think so, Your Honor, and it's certainly in the summary judgment record. Again, that's the police department, the department most responsible.
Did Judge Cogburn deal with whether it was admissible or not?
I don't know if he did, Your Honor. I'm happy to look and
Did
follow.
you all have an argument on this case before the judge, or was it ruled on papers?
Judge Cogburn did hold a hearing on this motion, Your Honor, so there was full opportunity for briefing and airing of any issues. And based on the full record, Judge Cogburn properly recognized that there's plenty here for a reasonable jury to construe the evidence in our favor and find that Officer Lohr was out of the car's trajectory. I heard there being a dispute even between Officer Lohr and his counsel. I heard his counsel say today that he questions Officer Lohr's claim that the car was moving at 25 to 30 miles per hour. So I think that only reinforces what the district court recognized, which is that a reasonable jury could easily discredit Officer Lohr's claims in his deposition. And at this stage, the district court was required to assume that the reasonable jury would do that, and this court is bound by what the district court concluded about the construction of the evidence. I also wanted to point out.
Did you argue the case in front of Judge Cogburn?
I did not, Your Honor. That was my co-counsel, Michael Littlejohn.
Now, if we sustain Judge Cogburn, are you all going to represent this fellow at the trial?
Mr. Littlejohn will. My office actually focuses on appeals, so we're not equipped.
You're the appeal expert.
I am someone who does appeals. That's correct, Your Honor. Last thing I wanted to point out is just that, Judge Berner, as you said, I think the critical facts here are that the car passed the officer, and it passed him at the time that he fired his shots. That was the critical fact in Waterman that distinguished the first volley from the second volley, that unlike the first volley, when the car was coming towards the officer, at the time of the second volley, the car passed him. past them rather. And this court held that in that moment and in that position, the officers were out of danger. They did not face a danger of being hit, and thus there was no justification for deadly force. The other factor that Waterman considered actually weighs even more in favor in this case, because remember, the other critical factor in Waterman was the fact that the officers knew that just prior to the first volley, the car had already been used as a deadly weapon. The car had already attempted to run an officer off the road. And the court took that fact to inform how a reasonable officer would anticipate whether or not at the time of the first volley, the car might turn towards the officers. Here, in contrast, Lohr himself admitted, and this is at JA 885, that he had no reason to believe that the driver of the car had committed a violent crime or would commit a violent crime. And so there was even less reason to think that the car was going to be used as a deadly weapon, on top of the fact that it just couldn't, on top of the fact that, as in Crine, as in Williams, he was in a position where he was, quote, no longer in danger of being hit. That's Crine at page 190.
Well, these all seem to be factual disputes that we lack jurisdiction to consider.
I completely agree, Judge Berner. And so this court could easily just say all of the arguments that Lohr has raised are simply not within the court's jurisdiction and reject the appeal for that reason. If there are no further questions, I'll just reiterate that the district court's factual determinations resolve this appeal because they line up perfectly in the exact terms with the rule in Waterman. Lohr cannot dispute those determinations in this appeal, and they're all this court needs to affirm. Thank you.
Thank you very much, sir. Mr. Bader?
This case really finds itself almost in the middle of Waterman. I mean, Waterman talks about the shots that are fired as the vehicle is coming at the officers, that those were constitutionally permissible. And then it talks about the second volley after the vehicle was driving away from the officers. We're in the middle here. And what we would argue is that taking all this evidence in the light most favorable to Caliste, Officer Lohr was in this vehicle's direct path before he fired. The court noted that. Officer Lohr had about 2 seconds between when he said, "Get out of the car." He can also be seen holding up his hand, and when the first shots are fired. The reason the shots are fired into the side of the vehicle is a product of Officer Lohr's reaction time. And as we put out in our brief, it would be, we would argue an incorrect application of Waterman to say that it would allow deadly force when a vehicle is coming at the officers, but say deadly force is improper if the officer had such limited time and space to react that by the time their finger pulled the trigger, the car was now next to them. If, as here, what the evidence shows is they were so close to the officer that the officer could have been run over in about 1 second had the vehicle turned. That's discussed in Waterman. That's what the body-worn camera footage shows here. That's what the evidence shows here. That is where this case is distinct from Williams versus Strickland, where this court goes out of its way to say we have competing factual evidence as to where this officer was when the shots were fired. That does not exist here. Everybody agrees where the officer was and where the shot hit the vehicle. The dispute is how the officer perceived it, and even that's how the district court framed this issue in denying summary judgment, saying that a fact finder could find that his view was unreasonable, but of course reasonableness in this context is a question for the court. Unless the panel has any questions, I want to be helpful, but I don't want to repeat myself. We would ask for this court to reverse and find that Officer Lohr is entitled to qualified immunity.
Thank you very much, sir.
Thank you.
We appreciate it. And we'll come down and greet counsel, and then we'll take a short break, Madam Clerk.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
May be seated. Our next case is Accord versus Steele. Mr. Carroll?
Yes, Your Honor. Mr. Carroll, on behalf of the estate of Michael A. Cord. This will be the second time in this case Mr. Carroll has gone up against Mr. Carroll, so I'm glad at least one Mr. Carroll will win this argument. If the court is inclined to reverse, it should provide clear, workable guidance consistent with prior precedent. A proposed holding might be where a fleeing motorist poses no immediate threat to officers or civilians, and no new facts emerge to elevate the level of risk after officers have adopted non-lethal tactics. The use of deadly force, particularly through a maneuver known to be deadly, violates the Fourth Amendment. An officer is not entitled to qualified immunity where a reasonable officer would have known that such conduct was clearly prohibited under prior established law. In that way, this case invites the court to affirm a critical Fourth Amendment principle. Mere flight is not enough to
Okay,
warrant.
now, you know this was more than mere flight. How fast was he going?
The record indicates that he was going anywhere from 80 to 103 miles an hour, and also that he was slowing down just
And
prior
on
to the
on
collision.
a state route, right? Was he on a big interstate highway, or what was he, where was he going 100 miles an hour?
Well, when you look at the video at the very beginning, where he was, before he got into the town, he was on a 4-lane rural road. It was-
Right, but we're talking about what happened at the end, right?
Well, we're talking about
So we
what,
went through, how fast was he going when he went through the town?
well, he was marked as going 103 miles per hour when he entered the town city limits, which was about 14 seconds prior to the collision. However, the evidence in the case from our forensic experts suggests that he was going about 70 to 72 miles per hour, I
What was
believe,
the
at the
speed
time.
limit there in the town?
When he crossed into the town, the speed limit was 40 miles an hour.
Okay, so he was going about twice the legal limit.
I mean, if you can believe that he was accurate, that Officer Vinson was accurate in getting the speed at that point, I think he was just using his own speedometer to clock that. He was going more than 2 times the speed limit at that point.
Okay.
Town of Narrows.
The town of Narrows, yes, sir. And what's important about that is that it's at that 14-second point that Officer Vinson, who's been trailing the motorcycle driven by
He's
Mr.
been chasing him since Harrisburg.
Within Harrisburg, it's been about 3 minutes or 5 miles to the point of the collision, Your Honor.
Westbound on 460.
That's correct, Your Honor. And for most of that, separated by a relatively wide grass median, which does narrow a bit when it comes into the town of Narrows. But what's important about that 103 miles per hour, 40, when he's coming into the 40, that was a communication from Officer Vinson, who's been trailing this pursuit the entire time, that was made 14 seconds prior to the collision. Officer Stille, after that, responded, "I'm going to stop traffic, see if I can get him to slow down some." So his understanding at the time, his communication at the time, was that this was not an incident that warranted the use of deadly force. In fact, he communicated, knowing that he was going 103 miles per hour at a 40 mile per hour zone, entering the town of Narrows, that the proper course of conduct was to get him to try to slow down. And in fact, he testified that that was his intent all along, was to get him to slow down and then back up out of the way if he didn't stop.
Well, yeah, I mean, that's the first goal, is to stop the person. He didn't stop, he fled, and then second, slow down, and he didn't do that. I mean, I don't think any officer's initial intent is to shoot somebody,
Well, that's right.
and I don't,
And it's not so much, again, about what Mr. Stille's subjective intent was per se, but rather what an objectively reasonable officer would have done under the same circumstances. However, given that non-lethal tactics were initially the course of action that was determined by Officer Stille, the question I think also becomes, if non-lethal tactics are objectively reasonable at that point, 14 seconds out when he's going 103 miles an hour in the city limits, does anything
But
happen?
the 14 seconds, you're saying that's from the town limit, the town line, when he entered Narrows, until the collision with the officer?
Yes, sir, that's right. Does anything happen within that?
Third Street, where's that in relation to the bridge?
I'm not sure where the bridge is. That's at the rough spots, I think, as they describe in the record, where there's
Where
like,
is it in relation to there's a stoplight there?
there's, the collision occurs at a intersection that's not controlled by a stoplight.
Okay. There's a marathon station.
There's a
That
marathon
intersection.
gas station.
But I'm trying to find out where that intersection is in relation to where the stoplight is, where the bridge is.
I believe.
You don't know the answer to either one of those.
I believe Officer Stilley testified that the rough spots was about 1.5 miles away. I believe that's
Rough
what he
spot.
testified. That's where the mark saying he was entering the 40-mile-an-hour zone, going 103 miles an hour. It's called the rough spots locally because I guess there's a rough patch of road there, and it's
That's
seemed
when
to,
he came into town.
that's when he was roughly entering the town limits. Yes, sir.
It's a narrow valley beside the New River, is what that is. That's called Narrows. And the town, as I recall, is on both sides of the river. And that highway, 460, parallels the river on the right-hand side of the river, that going downstream. And it's right close to the West Virginia state line.
It is very,
And it's heavily traveled. And there's a big chemical plant or some kind of facility there that he passed called Celanese, close to Parisburg and Narrows.
yes, sir, that's right. And much of that evidence is in the record. In fact,
But that's a heavily traveled highway.
I don't think there's any evidence in the record with regard to how heavily traveled that highway was. Obviously, the
Well,
court can,
it's enough traffic that the state of Virginia decided to make a 4-lane highway through there. And they did, years ago. It was 4-lane before they had interstates.
that may be the case, Judge King. I don't believe any of that evidence is in the record. I believe the evidence in the record with regard to the video evidence that occurred at the time shows that there was not that much traffic on the road at 10 p.m. that evening.
Well, it was late in the evening,
Yes, sir, it was at 10 p.m. in the evening, approximately.
but there was other traffic.
There was other traffic, and the video evidence very clearly shows that Mr. Acord, while speeding, did not force anyone off the road. He did not swerve into oncoming traffic at any point in time, and he did brake going around curves. Officer Vincent even testified that he believed that he caught up to Mr. Acord at one point because he was slowing down to go through a curve safely, which is important to the question of the immediacy of the risk in this case, a question that was pertinent to the last argument, because there was no immediate risk, as there have been in other cases that this court and the United States Supreme Court have evaluated and found to be constitutional with regard to the use of deadly force, such as Scott v. Harris, the Molyneux case, the Abney v. Coe case. All of those cases involved conduct by fleeing motorists that elevated it beyond the act of simple fleeing and created a more immediate risk, such as using the car as a weapon in the past.
But why isn't going 100 miles an hour on this road through small towns, why doesn't that create an immediate risk
Well,
to anybody who could have been on the highway?
It creates a general risk to anyone who's on the highway, there's no doubt. And the faster you go, clearly,
It's a substantial risk to anyone on the highway.
the faster anyone goes on the highway, the more significant the risk becomes that if they crash into someone else, that there's going to be an injury.
Well, 100 miles an hour in a 40-mile-an-hour zone.
Well, that is,
In a populated area.
it is in a,
There is a small town there, right? There's a gas station?
Gas station right there where the collision occurred.
it occurred right where there was
Right
Right
Marathon
here,
a gas
it's
station.
JA 552.
That's right. So all that's right. But this court held as far back in Tennessee v. Gardner that the use of deadly force to prevent the escape of felony suspects, whatever the circumstances, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape, where a suspect poses no immediate threat to the officer and no threat to others, the harm resulting from failing to apprehend him does not justify the use of deadly force to do so. This has sort of guided all of the cases up to this point through Williams that have delineated whether or not deadly force may be used if there is not an immediate risk. And that question really, I think, affects both the qualified immunity analysis and the Fourth Amendment analysis here. And so the question for the court then becomes, in the circumstances of a fleeing motorist, what constitutes an immediate risk? And I believe that there are, with regard to whether there was...
Fleeing motorcycle, 103 miles an hour, is a substantial risk.
You know, it's a,
Well, Your Honor, it's not a question of whether it's a substantial risk. It's a question of whether it's an immediate risk.
It's an immediate substantial risk to the public.
An immediate risk of
The
serious...
people on the highway, the people adjacent to the highway.
I understand that, Your Honor, but if we look at one of the cases, the Ailman case that this court recently decided, in that case, the court said that an individual holding a gun that wasn't pointed at the officer wasn't an immediate enough of a risk. It might be a substantial risk, and certainly if he pulls the gun up and points it at the officer, it becomes an immediate risk, but the immediacy involves that precise moment when the choice to use deadly force is employed. And in the case that the court was discussing earlier in Waterman and Williams, in both of those cases, not only was there an actual immediate risk potentially at some point, definitely in Waterman, potentially in Williams, but the moment that the car passed, the risk was no longer immediate to the officers.
stopping cars because they saw there was a risk to the vehicles on the road? There was a van that they stopped because that the officers had to put their sirens on and stop because it was about to pull into the highway. There was a risk.
Right, but again, there's a difference between a risk and an immediate risk of serious death or injury to an officer or others. And in this case, at the time that the force was employed, any of the risk theoretically that Officer Stilley was worried about, or that an objectively reasonable officer might be worried about, had diminished, not increased. The van that he was concerned, Stilley testified, about someone turning in front of the pursuit, and that's why he was stopping traffic, to get people to stop from turning so that the pursuit could pass through. The van was stopped. All the cars were stopped. Nobody was turning. The motorcycle was slowing down. It was no longer going 103 miles an hour. It was going 70-something miles an hour. I can't remember the precise
In the 40
speed.
mile an hour zone.
But slowing down and braking. There was the undisputed evidence. The evidence in the record is disputed, but drawing the inferences in the light most favorable to the plaintiff, he wasn't. Mr. Acord wasn't out of his lane of travel at any point. Even at the moment before this occurred, he didn't cross over into oncoming traffic. He hadn't lost control of his vehicle. This is all pointed out in the Knott Labs forensic report, that any loss of control, which may have justified a potential split-second decision, and it's a matter of factual dispute for the jury in this case, from the plaintiff's position, that occurred after Mr. Acord was reacting to the movement of Mr. Stilley's car when it pulled out in front of him. So at the time that, based on the record...
He crashed into the driver's side door.
He crashed into the driver's side door, yes.
Of the police car.
Front quarter panel and the driver's side door, I believe, Your Honor. Yes.
Lucky he didn't kill Stilley.
Well, Stilley was uninjured, Your Honor.
He was thrown all around the car.
He was, but he testified that he was uninjured in the case, Your Honor.
Lucky he didn't get killed, I said.
He may be, but he also made a choice to place himself in that position. He claims that was to protect another motorist, but we dispute that.
So did
He said, and it's uncontradicted, he was doing it for that purpose.
It's highly contradicted that he was doing it for that purpose, Your Honor. He never ever...
He was trying to stop a tragedy from occurring there. middle of Narrows, in the middle of the night.
He had asked Officer Vinson what needed to be done to help the situation, and Officer Vinson told him that he couldn't think of anything that he could do to help the situation. And he nevertheless decided to try to prevent some cars from potentially turning in front of the pursuit. Okay. And then he made this final deadly maneuver. If I may finish this thought, my time is
Go right
running out.
ahead.
He made this final deadly maneuver. And then the real dispute comes in, I think, for the jury in this case as to why he made that final maneuver. And he offered an explanation in this case after the litigation began that he did it to protect the occupant of this van. And in those circumstances, were the jury to believe that, it would then create a new split-second decision-making process that might afford him protection under the Constitution. But he never said that until the litigation began. And in fact, before the litigation began, in his initial statement in this case, he didn't mention anything about trying to protect a van. And he described the movement as something that was unintentional, in fact, that he wasn't intentionally placing his vehicle anywhere, that his foot accidentally rolled over off the brake and onto the gas as he was trying to brace for impact in this case. And this court has held in Caraway and other cases that those types of contradictions create real factual disputes that should be resolved by a jury. Thank you very much. We ask the court to reverse.
Thank you, Mr. Carroll. Mr. Carroll?
Good morning, Your Honors. Jeremy Carroll, on behalf of the defendant, Officer Chad Stilley. Mr. Acord led police on a high-speed chase at over 100 miles an hour, entering a 40-mile-an-hour zone in the town of Narrows. He did so on a motorcycle, very difficult to see, at night. He was heading towards an intersection, as Judge King, as you've indicated, where the Marathon gas station was. I also believe there's a Burger King there. That had, as the district court found, steady traffic at that intersection. Further, as he's coming into town, a half mile further down 460, is a mudslide that has closed two lanes of 460, forcing the two westbound lanes over into the eastbound lane. So you have what the lower court determined was an unusual and narrowed traffic pattern. And I believe, Judge King, the record reflects that that's where the stoplight is, where the mudslide was, and the lane closures was where the stoplight is. I believe that was Officer Stilley's testimony. And Judge King, you asked about the Celanese plant. That was further west. I think the pursuit passed the Celanese plant. But what's relevant about the Celanese plant, Your
Further
Honor-
east.
further east, yes, sir. What's relevant about that plant is there's testimony that that plant was undergoing a shift change, which is what led to some of this increased traffic. Even though this was 10 o'clock at night, there was a shift change at that plant, which led to some of this traffic. Indeed, Mr. Pitzer in his van was pulling into the Marathon before heading to that plant for shift change. Mr. Officer Stilley, Your Honors, was located at that intersection of 3rd and 460, and this is an area where there is no median at this point. The lanes are next to each other. There's no turn lane either, so anybody who's in the left lane westbound is just a few feet from somebody who's in the left lane eastbound. Officer Stilley, confronting this risk to the other drivers in the area, confronting the risk to the potential drivers down the road where the lane closures occur, acts to stop the chase. The outcome of this case, respectfully, is guided by the Supreme Court cases in Scott, Plumhoff, and Muhlenex and their progeny, cases which dealt with high-speed chases, cases which addressed the degree of risk that allow an officer to use force to bring a chase to its end, to its conclusion.
But aren't the facts here distinguishable from those cases? As I recall, Mulex, for example, in that case, it was a much longer chase. The driver claimed to have a gun and threatened the officers. There were reports that the driver was intoxicated. Here we have none of those facts. In fact, they're all to the contrary.
You are certainly correct, Judge Berner, that there are factual distinctions on the margins between these cases. I believe in Muhlenex it was a longer chase, though I think the driving was maybe even a little, I think it was 85 miles an hour in that case. I may have Muhlenex and Scott confused there. But there are various factors. There were threats made in Mullinex that were not made in this case. Absolutely
So
correct.
those factual differences don't seem to me to be on the margins. They seem pretty substantial. And in fact, what your colleague had said is that, in fact, Mr. Acord was slowing down, that he had not left his lane, that he was not swerving. There was no suggestion that he was armed. I mean, at a minimum, that strikes me as a question of fact.
Well, there certainly were differences in those cases about the risk, but here where you have a 100-mile-an-hour motorcycle, he did switch between the two westbound lanes, so he wasn't just staying in a single lane. He did not cross into the eastbound lane, that is correct. But he is speeding at 100 miles an hour coming into the 40 zone. That is the communication from Officer Vinson to Officer Stilley. There is no change in that speed ever communicated to Officer Stilley. I believe at one point in the brief, Mr. Carroll references brake lights on the motorcycle. Well, Mr. Stilley's perspective, Officer Stilley's perspective, would have never seen those brake lights. He believes that that motorcycle is still coming at over 100 miles an hour. But I think on the qualified immunity issue in particular, Judge Berner, there's no case that says driving in this manner as opposed to driving in a manner in Mullinex or Plumhoff or Scott somehow isn't protected by qualified immunity. There's no case that looks at driving similar to as Mr. Acord was doing in this instance and says, okay, well that type of driving, it's clearly established that you can't stop him in that circumstance. And Williams and Waterman respectfully don't provide that either, because those are not high-speed chase cases. And the reliance on Williams, we submit, is misplaced.
What about opposing counsel's point that Stilley did not say any of this in his initial statement as the reason? And I think he said that it wasn't intentional. Or at least that's what opposing counsel said.
Yes, Your Honor. In the first statement he made that evening, there is a reference to having the van stopped, or the vehicle, I think is the actual word he used there. Vehicle stopped in the left eastbound lane. So there's clearly a contemporaneous reference to the van. And we supplemented the record with the testimony of Chief Radcliffe.
But the fact that the van is stopped goes in appellant's favor because there's no threat then, no immediate threat.
Well, he had obviously Chad Stilley had been the one to pull out and get the van to stop. And if you look at the video, and the video is very interesting and powerful evidence we submit. If you look at the video, particularly the one from Vinson's perspective, and if you look over the hood in the 10 seconds after the accident, you see Mr. Pitzer's van there. You see his left blinker, you see him turn the blinker off, back up, and then move over to the right shoulder and pass. So the fact of the van with its left blinker we submit is demonstrated in the video. And you say not in the path, Judge Thacker, and I don't think that's what's required in this instance. And that's where Williams, for example, if that is a case that requires the danger to be in the direct path, is different than this case. If
But
you
I
look-
guess going back to, I'm sorry, because I got you off field. My first question was about the fact that the officer didn't say this stuff in his initial statement.
Well, and I'm sorry, Your Honor, forgive me for not finishing that thought.
That was my fault.
He did say that it was, he noted the van's existence in the first statement, and that day at the scene, talking to Chief Radcliffe, and we supplemented the record with Chief Radcliffe's deposition testimony, Chief Radcliffe testified that indeed Officer Stilley did tell him that day, and then again, the video which demonstrates the van, shows the van, we suggest, is further support. On the intentional issue, if there's no intentionality, if this were truly an accident, then I don't think it's a Fourth Amendment violation to begin with. So I think saying it was intentional actually cuts against my client's interest because I think that's what makes it a seizure in this instance. So, that's our perspective on the intentionality question, Your Honor. But going back to Williams, upon which Mr. Carroll puts so much emphasis, Williams is factually distinct, as Judge Dillon noted in her opinion. Williams occurred entirely within a parking lot. There was no high-speed chase component at all. The car backed up, turned the wheel and then pulled forward. And as counsel in the previous argument indicated, there was a fact issue as to whether the gunfire was before, while it was passing, or after he had passed the officers. That's just factually distinct from the case we have here, which again is a high-speed chase where citizens and motorists at this intersection and then further down where the lane closures are placed at risk. I would respectfully submit that no objective officer could look at Williams and credit Williams over Plumhoff and Scott and Muhlenex when dealing with a high-speed chase situation. Other distinctions with regard to Williams, again, footnote 5 of Williams is quite clear that there were no others. The test from Garner was whether there were officers or others at risk, and footnote 5 from Williams is quite clear that there were no others under consideration there. Well, here we clearly have others at risk. Again, Williams was not a high-speed chase case, and Williams did recognize that there could be circumstances, where there were circumstances when you could be outside the zone, outside the direct path and still be in danger and justify the use of force. There's something else about Williams, and I
Do you
think
think
it's...
there could be a case where there's a high-speed chase and nobody is at risk, and then therefore there would not, the use of deadly force would not be justified? In the middle of nowhere, high-speed chase, would then the use of force be justified?
It's not this case, Your Honor, and I think if you look at Scott versus Harris, Your Honor, at the time, footnote 7 in that case, discusses that at the moment the officer used force, there was no one at risk. There was no one in front of the suspect at the time the officer used force. And they even credited the officer for waiting until there was no one else at risk. And if you look at Plumhoff, Your Honor, was a case where the suspect was going to restart or initiate the flight. And there was no one specifically at risk, and the court said the use of force was reasonable to prevent those who might become at risk should the flight have resumed. So I know this is a round way of answering your question. There are circumstances where there does not have to be anyone in the path, as the Supreme Court has told us, for the use of force to be objectively reasonable. Scott, again, there was no Fourth Amendment violation at all, not just qualified immunity. Is there a set of facts where terminating a high-speed chase on some, straight road out west with very little,
Using deadly force to
Yes. Yeah, I
stop
mean, I would-
someone in a high-speed chase
Where
where
there's-
there's nobody at risk?
where there's no one at risk? Yeah, I could see that situation. I mean, certainly, but again, that's not this case because
You could see what, that would not,
there
that
could be a
that
s-
would
there-
be use of deadly force
yeah,
in
there
that
could be-
situation.
an unreasonable use of force.
Right.
There could be that situation. But we know that it's got to be something where there is less risk than presented in Scott and Plumhoff, which are cases which didn't require there to be anyone immediately in front of the suspect vehicle at the time of the use of force. And on the Williams issue, and again, why I think the reliance on Williams in this case is misplaced, Williams cited Garner. The quote upon which counsel relies so heavily is out of Garner. But if you look at Brosseau, cited in the Supreme Court case Brosseau, then Plumhoff and Muhlenex, and Scott, I believe, they all specifically state that you can't use that general proposition from Garner to create a clearly established right in a high-speed chase case. And that's what plaintiff is asking us to do. And respectfully, I think that would be leading the court into the trap that the Supreme Court has criticized circuit courts for in the past, and that is defining the clearly established right at too high a level of generality. Williams is not a high-speed chase case. So taking Garner and applying it to Williams makes sense. But if you then take that same standard and apply it to a high-speed chase case, I think you run headlong into the Supreme Court precedent, starting with Brosseau and all the way through Muhlenex, which reject Garner as a source of a clearly established right in a high-speed chase case. And I do think it's also important to mention Waterman, which again I know was discussed in your prior argument. Waterman recognizes that you don't have to be in the direct path. I think it uses the terminology general direction or general area when it's talking about where the officers were in Waterman. So for those reasons,
What do we make of the fact that Officer Stilley was off-duty, that he was specifically told that he wasn't needed, that he essentially inserted himself into a situation where no one had sought his assistance? Are those facts at all relevant to our analysis?
Well, he was on duty. He is on duty. He's at the marathon doing what he called in his deposition community policing, talking to folks. But he's in uniform, has his squad car. He's on duty. Now, he does, I think what Your Honor is referring to is he does radio Vincent and ask if he can do anything to help. And Vincent says, I'm not sure what you can do. I'm on him pretty good. He's at 100 right now. That's not a rejection. That's not, and indeed, Officer Vincent testified in his deposition that he wasn't rejecting the offer of
He was a
help.
police officer for the town of Narrows, wasn't he?
Still is Town of Narrows.
But he was a police officer for Narrows, and this fellow's coming through his town at 103 miles an hour.
Yes, and he's coming into an intersection which Officer
Doesn't
Stilley
need any
testified.
permission from the police officer that's chasing him.
Correct. And there was some discussion about, well, why didn't Stilley contact his supervisor in briefing? Well, Town of Narrows is a small community. He was the only officer on duty at the time. He did not have a supervisor on duty at the time. And, Officer Vincent testified that he was not aware. So, Vincent's question and Vincent's answer is largely irrelevant because he's not aware of the degree of traffic at this intersection, nor is he aware of the lane closure further down, which created the narrowed and unusual traffic pattern. So Vincent's perspective, Judge Berner, in asking the question and in the answer, or answering the question, forgive me, is, we think, largely irrelevant. It's Stilley's perspective that matters in this instance, and from his perspective, he saw the risk. And again, I think the video is important here, because you see 15 eastbound cars as the pursuit is heading towards town. They pass 5 westbound cars, one of which pulls off to the side of the road. From Officer Stilley's dash cam, you see 3 westbound cars in the moments before the accident, and you see 1 eastbound in the second before the accident and another eastbound in the second after the accident. And then you get 6 more eastbound cars after the accident. So clearly there is the steady traffic that Judge Dillon found to exist and that created the risk in this situation. And looking back at Scott, the culpability factor, which is so important in Scott, certainly exists here as well. The danger that was present was created by Mr. Acord. So the evidence in the form of Officer Stilley's testimony, the video which shows the vehicles, again, the video which shows the van in the left lane with the blinker on, and of course the testimony about the lane closures half mile down the road, certainly warrant or justify the use of force. Under the Scott standard, the rule of Scott, you'll recall Scott adopted what it called a sensible rule that if a law enforcement officer uses force to stop a dangerous high-speed chase, that's reasonable and not a Fourth Amendment violation. We've cited a number of other circuit court cases that stand for the same proposition. I'll mention Pasco, Fifth Circuit 2009, the Supreme Court in Mulinex even cited to this case. In that case, there were no other vehicles, pedestrians, or bystanders in the area, and the court ruled that the use of force was not dependent on an actual bystander being there. It's the safety of those who could have been harmed if the chase continued. And that's important, and you also see that in the Shantz, a 2021 11th Circuit case, and Tussis, a 2023 7th Circuit case. And I mention those because counsel argues on brief that Mr. Acord could have passed this by if Mr. Officer Stilley hadn't pulled forward and continued on his way. Well, Plumhoff, Pasco, Shantz, Tussis, those cases all indicate that's justifies the use of force to stop that from happening, to stop him from passing by, ramping back up to 100 miles an hour, and continuing on down until he gets to the lane closures at 460 and continuing to create risk to individuals on the highway. running out of time, I'll quickly say there's nothing about Williams which would create a clearly established right in this case. It sheds no light on high-speed chases. It sheds no light on assessing risk in facts such as those Officer Stilley confronted. It sheds no light, to Judge Berner, to your point, it sheds no light on the type of driving that by a suspect that is or is not sufficient to create an immediate risk of harm. The Morrow case had an interesting quote. 3 cases, talking of Scott, Plumhoff, and Milinex, affording qualified immunity to officers who use deadly force to end police chases, do nothing to foreclose using deadly force to end police chases. And I think that's exactly what we have here. The clearly established law, if anything, comes down on the side of Officer Stilley. Scott, Plumhoff, Milinex, the robust jurisprudence from other circuits comes down in that area as well, supporting the use of force. We've also argued that Judge Dillon could have concluded that there was no Fourth Amendment violation. As my time is winding up, I'll just rely on the briefs for that point. I did want to just briefly touch the battery claim. This court has held that the battery claim would be subsumed by the Fourth Amendment claim. The Fourth Amendment claim, if dismissed even on the basis of qualified immunity alone, would also go away. On the good faith immunity issue, they are congruent, as this court held in Wingate, and it should be dismissed on the same grounds as the Fourth Amendment claim. Happy to answer any other questions the court may have. If not, we respectfully request the court affirm the lower court's decision. Thank you.
Thank you very much, sir. Mr. Carroll?
Thank you, Judge King. Just very briefly on the good faith portion, I know we didn't discuss that in my first time up. They're not the same, and we just rely on the briefing on that. There's a subjective component there that goes into the officer's thinking. There's evidence regarding whether it was good faith or not, and the Virginia Supreme Court has very clearly directed that that's a jury issue. It's not collapsed into the objective reasonableness argument. That portion of it does rise and fall, the objective portion with the qualified immunity analysis, but because the good faith immunity has a subjective component as well, they can't be collapsed together. And so if this court affirms the ruling with regard to qualified immunity or the constitutional violation, it should remand this case to state court for adjudication of the battery claim with regard to the good faith and to find that there wasn't a proper application of good faith immunity at the summary judgment stage by the district judge. With that being said, to Judge Berner's point, of course it wouldn't be appropriate to kill everybody that's driving 100 miles an hour no matter what the circumstances. I can't believe that the court would think that that was plausibly something that any objectively reasonable officer would believe, that they are armed with, merely by flight or speed, the opportunity to execute anyone that they deem fit. That's not, we don't need a case on point to tell us that that's not objectively reasonable. And I just push back on the idea that somebody needs to be driving around on some deserted desert highway in the far west in order to have a right to live, even if they happen to be out driving too fast. But as we turn back to this case, another thing I'd like to point out is we have to be honest about this situation, and I understand that the qualified immunity analysis and clearly established imposes a lot of legal fiction sort of on reality, but these officers are not out in the field comparing cases and trying to decide whether they align more with this case or that case. What happens is the cases are handed down, and it influences the training and the policies, and they're supposed to behave in congruence with their training and policies. That's what really happens. I don't know if that's in the record, but we all know that they're not comparing cases on the scene, no matter how slow or fast developing the circumstances are. And that's why a step-by-step playbook isn't required, because officers aren't going to really find the latest case and compare the precise facts to see whether or not their conduct is constitutional. What this court requires is that the officer be reasonably on notice. And there's a lot that puts an officer on notice in this case with regard to clearly established as to whether or not killing a man who's speeding but posing no other immediate threat to anyone is unconstitutional. We've talked about the Garner case already, and we've talked about Williams. But we've also talked about some other cases, but not from the perspective that I think is important, and that's this line of cases, Scott and Molyneux and even Abney v. Coe from 2007, the Fourth Circuit. This court did say in Williams that officers don't need the playbook and that they're expected to use logic and reason and common sense when they act, and that they, if know X is illegal, then they know Y is illegal as well. And what Scott and Molyneux and these lines of cases do is they define, in the context of a high-speed pursuit, what constitutes an immediate risk. If you're ramming cars, threatening to shoot police officers, swerving into other traffic, showing that your ongoing conduct is going to continue to pose a high level of risk if the pursuit is not terminated, then it presents an immediate risk. It could dissipate, but it presents immediate risk that warrants the application of deadly force under those circumstances. And actually, Waterman incurred after a high-speed pursuit, although it was no longer high speed at the time of the facts in that case. What that means, using common sense and drawing inferences and the like, and knowing that Garner says you can't just kill people because they're running away from you, there has to be an immediate risk. And that this court said in Ellman that even holding a gun isn't immediate enough, if you could pull it up 1 second later and shoot that police officer, that there has to be something that enhances the conduct beyond merely fleeing at a high speed. There has to be conduct that shows an immediate risk at the moment that the deadly force is executed. And in this case, there was no escalating moment. There was simply a driver who had been speeding and who was slowing down. And regardless of whether or not Mr. Stilley could have seen his brake lights, there had never been communicated to him any risk at all. And he relied an awful lot on what he says his perceptions are. And I think at this stage, those inferences have to be drawn in favor of the plaintiff. We would ask that the court reverse and remand the case back for trial on the merits. Unless there are any other questions, thank you very much.
Thank you very much, sir. We'll come down and greet counsel, and then we'll go to our final case. In our final case, Moretti versus Thorsdottir, how do you pronounce it? Mr. Megan Tauber, you're representing the plaintiff.
Yes, sir.
Good to have you with us, sir.
Thank you, Your Honor. Good morning, and may it please the court. My name is Alan Mygat Tauber, and I represent the appellant, Mr. John Scott Moretti. Under this court's 2007 decision in Miller versus Prince George's County, it is clearly established that an officer cannot lawfully make intentionally or recklessly false material statements or omissions in order to obtain a warrant. Any reasonable detective would have had reason to doubt the identification made by the victim in this case and would have informed the magistrate of the conflicting identifications as well as her failure to corroborate any part of the victim's story. Detective Helga Thorsdottir engaged in malicious prosecution under both the Fourth Amendment and Virginia law when she swore out a warrant based on two facts. First, the victim's ID, and second, that my client had a gun in his home. Courts have held that a victim's ID can be enough if the victim is reliable. But in
And
May,
both those things occurred here, right? The victim did identify appellant twice by name, and he did have a gun in his home.
yes, Your Honor,
So
like,
those facts are accurate, it's just you don't think that was enough for her to have gotten an arrest warrant?
no, Your Honor, we think that she withheld vital information, that when she identified my client, it was not her first identification of her abuser, and that a year prior, she identified somebody who was her father's friend and living in her home at the time.
Right, did this officer know about that?
Yes, she did, Your Honor.
Can I find that in the record, that the officer knew about that prior identification?
We alleged at J&A, pages 8 and 9, paragraphs 23 through 27, and that the detective, or sorry, and
Oh,
and
wait,
that,
is that your, okay.
and then in our complaint at paragraphs 26, 27, 125, 142, and then in 115, 17, and 18, and JA 42 is the detective's write-up, where she describes her summary of the earlier Alfaro report, where the detective said that he had received that, the
Right,
identification.
and did she have that summary at the time of the arrest warrant?
She had it 2 years before, or a year before the arrest warrant, Your Honor, yes. The arrest warrant was sworn out in May of 2020. Detective Thorsdottir had that information in September of 2019, when the case was referred to her.
And that's on JA, what did you say?
That's JA 42, the detective's
Okay.
write-up of the summary of the report she had received from her supervisor. So we believe that, you know, so yes, so she made, you know, again, so the victim, I did ID my client, and yes, my client owned a firearm, like 44.6% of all Virginia residents, and my client
Right,
is
he was
along-
an officer, so,
Yes, so there's about 1,000% chance that he was going to own a firearm.
Right.
But more importantly, they don't identify the kind of firearm. At the time of the allegation, it was 6 years before, and the victim identified that my client had a handgun. He is prepared to testify that at the relevant time, he only owned long rifles, and that while the search of his house may have uncovered a handgun 6 or 7 years later, that does not indicate that he had a handgun at the time and would not be probative of the decision. But most importantly, we think there were 3 facts the detectives withheld from the magistrate judge that would have undercut probable cause. First of all, the initial interview that was withheld from the magistrate was incredibly problematic, and the victim was told that she could only leave this 5-hour interview if she named her abuser. We think that is coercive and was an inappropriate means of getting an identification, and even the detective supervisor, First Sergeant Tyrell, expressed concern about the interview. And that was in her email at JA 54. Secondly, perhaps most importantly, the prior inconsistent identification. When she was calling or communicating with a suicide hotline, the victim in this case identified her abuser as a friend of her father's and someone who at the time was living in her home. Those 2 facts were absolutely available to Detective Thorsdottir when she swore out the warrant. What we have found out subsequently is that her ID was far more specific. This was not a case of a young girl mistaking friend of my father and of my friend's father. She identified him as her father's best friend since high school, the best man at her parents' wedding, and somebody who had attended another wedding with the Jane Doe's family. We think that's enough to absolutely have identified that that information would have been available to Detective Thorsdottir if she had but sought it out, and she failed to do so. She never made any attempt, as far as we can tell from the record, to try to track down this chat transcript, which my client's criminal attorney was able to.
okay, so she didn't have the chat transcript at the time?
Not the chat, not the full transcript, no. She had a summary of it that was called in to the police. But we
Okay.
believe it was
And
reasonably
it was-
available.
I see. So it was, so she didn't have the chat transcript until after the arrest warrant?
Well, as far as we can tell, that's correct. We dispute. We think it's possible she had it earlier, but certainly that under this court's cases, she should have sought it earlier because it was reasonably available to her. and that it would have been very easy, Judge Thacker, for her to have, if she certainly had enough probable cause to get a search warrant for my client's home to search for child pornography, she would have had enough to get a subpoena for this chat transcript. And if she had done so, this case would have ended immediately. And the fact that these were material omissions, you are in an enviable position that you don't have to guess or create a counterfactual. Here, we have another reasonable police officer, the detective's own supervisor, who told her this ID is shaky. We have Assistant Commonwealth's Attorney Lowe, who, when she was provided with a copy of the transcript, no-load this prosecution. So we know for a fact that information was material because people who had access to it had reason to doubt the probable cause in this case. Our third and final thing that we think that the detective should not have withheld from the magistrate, but she did, was a prior disproven charge that my client created child pornography of the victim. In the same interview in which she disclosed the sodomy, which was the basis of the warrant, she said that my client used a small silver camera to take inappropriate pictures of the victim. The detective got a search warrant. She searched 3 laptops, 3 cell phones, 5 laptops, 3 tablets, SD cards, and thumb drives, and found no evidence that my client possessed or created child sexual abuse material. In her affidavit for that search warrant, she testified that in her expert opinion, as a detective who investigates sexual crimes, people who create child sexual abuse material hoard sexual abuse material. So the fact that the victim in this case claimed my client had created such material and they found no evidence in the exact same interview as the charge underlying the arrest warrant, we think that is probative and valuable information that the magistrate would have relied on to undercut probable cause. But beyond just withholding information, there actually is one affirmative misrepresentation in the warrant, in that it identifies the victim as 18 years old, which was true at the time the warrant was sought, but was not true at the time the accusations against my client were made. She was a minor. And there is a consensus of cases throughout the courts of appeals that have held that a bare allegation alone by a minor without some corroboration does not create probable cause. Instead, it may raise reasonable suspicion and would lead a reasonable detective to conduct an additional investigation, which Detective Thorsdaughter did here, but in 7 months of attempting to corroborate the victim's story, the only thing she found that corroborated anything was that my client owned a gun. And again, you flip a coin and search a Virginian's house, you're going to find a gun. At this point, Your Honors, if you have no further questions, I really...
So it seems to me you're asking us to find that there's no probable cause based on evidence that the detective could have obtained but didn't. So specifically, you're talking about the chat transcript. She could have accessed it, but she didn't. And as I read our case law, our cases say exactly the opposite, that the detective doesn't need to obtain all evidence as long as there's enough evidence to form probable cause.
Well, first of all, Your Honor, Judge Werner, I would say first, I would think that we are asking you to reverse it based on just the existence of the pure existence of the alternative ID which the detective had in her possession. But secondly, I would argue that
It's not clear. Okay, go ahead to your second point.
Sorry, my second point is that Savini versus Dixie, this court's 1988 decision, held that an objective inquiry must charge the officer with possession of all the information reasonably discoverable by an officer acting reasonably under the circumstance. So we're not saying she has to pursue every potential exculpatory lead. But if you get a referral that, hey, a victim called the suicide hotline, and in a chat transcript identified her abuser, I would think a reasonable officer would want to see the text of the transcript and not rely merely on a summary.
Well, it said, you call it an alternative ID, but all that she had in this summary is that she had disclosed that she was molested by her father's friend, and then the victim was told, when you're ready to disclose, contact the police department. And then, fast forward to the point where the officer talked to her and she disclosed a specific name twice.
Yes, but that name was inconsistent with the fact she had previously disclosed, which the detective had. It wasn't just a friend's, her father's friend, which he, by the way, volunteered. She didn't even ask the victim's father, is Mr. Moretti your friend? He had to volunteer that information during his interview, and he categorically denied that that description was accurate.
The victim and appellant's daughter were friends, correct?
Correct, yes, that is true. But the other thing is, she disclosed, as we've alleged she disclosed as part of that transcript interview, that the abuser was living in her house at the time she made that call. That categorically does not apply to my client. And so the detective would have had reason to believe that when she identified my client as her abuser, that that was not perhaps the correct identification. And that, in fact, there is reason to believe that the identification she made in 2017, or the earlier identification, is more accurate in that she was disclosing it to a suicide hotline. So that's indicative that she wanted this to be the definitive statement of who abused her. She thought that she was not going to be around to suffer the consequences.
Does the summary say that the abuser was living in her house? Or does it just say it was her father's friend?
The summary says that he was living in her house. At least that's what we've...
I don't...
Well, that's what we've alleged in our complaint. At this time, based on, we're at 12B6, we're entitled to an assumption that all the well-pled facts are accurate and true, and take all...
Even if I'm looking at the summary and I don't see where it says that?
Yeah, well, let's see, Your Honor.
Yeah, maybe you could just tell me where it says that.
Okay, let's see. That's J&A 8 through 9, paragraphs 23 through 27.
Wait, that's your complaint?
That is our complaint.
I'm looking at the summary itself. You said that the summary said not only that it was her father's friend, but that he was living in her house at the time. I don't see that in the summary.
I believe that's in Detective Alfaro's report on JA 35, which is what Detective Thur's daughter was summarizing on JA 42.
It says it was her father's friend. It doesn't say that person was living in the house.
No, wait.
Well, no, it says.
No, it does, now
Yeah, it
living in
does.
the home again.
You know, it's an odd posture because we have your complaint and then we have these documents attached to the complaint and some of them at least seem to favor the defense. And so I guess I'm struggling with how we weigh the statements in your complaint that conflict with the statements that are in the documents that are attached to your complaint.
Well, Your Honor, I would argue that's an excellent reason to let us go to discovery. We're not even at summary judgment here yet. This was a 12B6 motion to dismiss.
But you can't, so you're saying that you can say whatever in the complaint, even if it's inconsistent with the attachments to the complaint, and you get to go on with discovery?
No, Your Honor, I guess at that point,
Can't be right.
Well, I guess the appropriate remedy then would be to send us back to amend our complaint to make sure that our complaint matches the facts that we've attached. And let us amend the complaint and try to make it more correct. But in either case, at
Well, I
this...
believe our case law says that the exhibit prevails when there's a conflict.
Well, then in that case, Your Honor, I guess I would credit, again, I would credit then the exhibit, but as I just said, the exhibit does show in Detective Alfaro's report, which is what the Detective Thor's daughter was summarizing in hers.
And is Detective Alfaro's report attached to the complaint?
I believe it is, Your Honor. I believe that's JA 35.
That's the one, yeah, okay.
So we think this case is very similar to Wesley versus Campbell from the Sixth Circuit. There, you had an accuser who had psychological and behavioral problems. This case first came to Detective Thor's daughter by a residential therapist who was treating the victim in this case. Like in Wesley versus Campbell, there's evidence that they were never alone. My client told the detective that he was never alone with the victim. His children told the detective he was never alone with the victim. Had the detective reached out to my client's ex-wife, she would have told him that he was never alone. And I don't know about you, Your Honor, but if I want dirt on someone, my first stop is going to be the ex-wife. So the fact that the detective never even completed an interrogation or an interview of the ex-wife when she had indicated she was willing to speak with her seems like reasonably available information that a reasonable detective would have pursued. So again, the key here is that there were reasons for the detective to objectively and subjectively doubt the accuracy of the allegations here, and she never took any steps well, she took several steps and couldn't corroborate any of the evidence or the accusations, and took no steps to identify anyone else. In fact, as far as we can tell, the Commonwealth has never pursued whether or not the best man at the victim's parents' wedding is the abuser. As far as I know, and the Commonwealth is welcome to come up here and correct me, they have not pursued a case against the person who has now been definitively ID'd as the other potential abuser here. And so for that reason, we would ask that you remand this case to the lower court so that we can proceed to discovery. Thank you very much, Your Honor.
Thank you very much. You've saved some rebuttal time. Ms. Mooney?
Good morning. May it please the court, my name is Tara Mooney, and I am appearing today on behalf of Prince William County Police Detective Helga Thorsdottir. She is present today in the courtroom, seated behind me in the first row. This is a case about probable cause established by a victim eyewitness's identification. The precedent in this circuit, Torchinsky, says it's difficult to imagine better evidence or better probable cause evidence unless the officer were to witness the crime herself. The amended complaint is a frivolous lawsuit.
Except that the appellant never lived with the victim, and the appellant wasn't friends with the victim's father.
I'm happy to address that, Your Honor.
Yeah.
If you look at what was pointed out to you by counsel for Mr. Moretti, JA 35 and JA 36 is the Detective Alfaro report that he drew your attention to. And yes, at the bottom of JA 35, it talks about the complaint, the statements that were attributed to Jane Doe, not her statement to the police. It's the statement attributed to Jane Doe.
Right, it is different where she directly told the officer twice, appellant by name.
Agreed.
However, what about opposing counsel's argument that the officer should have at least sought out the chat transcript to do a more full investigation?
Well, I'm happy to answer that, Your Honor, but let me also add, on JA 36, Detective Alfaro, there was a forensic interview that took place. In Detective Alfaro's report specifically, she declines to answer questions about it, but when asked specifically, is the abuser living in your home, the answer was no. So when she's talked to directly by Detective Alfaro in that report.
That's on JA 36?
JA 36. So JA 35 is where the statement's attributed to her.
Oh, I see, in the next to the last paragraph.
Yes, Your Honor.
Okay.
She denies that the abuser is living in the home, and she says nothing else about, and never names that person in that earlier time frame of between 8 and 12 years old, she was subject to abuse. That was the earlier complaint that was referred to the police, but when she was talked to directly, her direct statement was, I don't have anything to say about this, basically, and then also, nobody's living in my home who's my abuser. So
Nobody's currently living in her home who's her.
the question was, is the alleged abuser living in your home? She says no. That was a direct answer to police that she gave at the bottom of JA 36, the Detective Alfaro report. So I'm sorry, was that an answer to your question? Because I'm happy to talk more about this.
Right, it was about, my question was about why she didn't seek out the actual chat transcript itself.
I'm not sure she knew that there was an actual physical document somewhere that had line-by-line chat, for example. But I will also say to Your Honor that in the allegations here, it is certainly not plausibly alleged on its face that she had that hotline transcript in her possession. In fact, it was conceded by counsel at the district court level in front of the judge on the motion to dismiss. Counsel at that time conceded that we know that she did not have it. We believe she did not have it in her possession, the chat transcript.
I don't think the argument is that she had it. I think the argument is that she should have made an effort to obtain it.
Right. Your Honor, I appreciate that. I would say to Your Honor that the law does not require her to chase down every exculpatory lead, every possibly relevant piece of evidence in the case before probable cause is established. And so the law doesn't require her to go get that.
And the summary says that at the time, the family was advised to contact the police when she was ready to disclose. And then when she did disclose to the officer, it was appellant's name twice. Now, that was wrong, but that's the information that was provided to the officer.
I'm sorry, appellant's name twice, what was wrong? I'm sorry.
That it wasn't him.
Who wasn't him? I'm sorry, I don't understand.
Appellant was not the abuser.
I,
You dismissed the complaint against him.
I'm sorry.
Do you know who the? Okay.
The null pros happened when, and if you look at the JA 88, it is Exhibit I on their amended complaint. It is the letter
Oh, no,
from.
it happened after the chat transcript came to light. I was just pointing out that I think is helpful to the officer, even though very unfortunate. I think it's helpful to the officer that the victim identified the appellant twice by name. I was merely making the point that this was too long, that he had to be under an investigation for something he did not do. Well, I assume the state thinks, at least they could not prove it because they dismissed it.
That's actually, I don't believe that's the reason why the case was null pros. The case was null pros according to my understanding, and when you see Exhibit I, which was attached to the amended complaint, the prosecutor null pros the case because of her unwillingness to move forward with the case.
Because the victim's unwillingness to move forward with the case.
Yes, Your Honor. Jane Doe no longer wanted to move forward with the case. That was
It had nothing to do with the chat transcript.
what my understanding is that the decision to null pros had to do with her desire to no longer move forward with the case.
What JA were you pointing to?
It's JA 88.
Okay.
Yes, Your Honor. Okay, so the amended complaint is a frivolous lawsuit properly dismissed by the district court because the plaintiff failed to allege facts to state a claim that is plausible on its face. Detective Thor's daughter also is entitled to qualified immunity. Probable cause really is at the heart of this case. It is essential to the case. It is a low bar, as the court knows. It's the totality of circumstances. We're allowed to use common sense. We think about what is human nature. It is important for the court to note that there were not lies or misrepresentations to the magistrate when Detective Thor's daughter went and obtained the felony warrants.
Hold on, I'm sorry.
Yes, Your Honor.
That's the JA 88. Yeah, at the end it says the victim's no longer willing to go forward with the prosecution, and I can understand why after all of this. But the very first thing in this JA 88 as the reason says, I've been made aware of the falsity of an argument that I made during the motions regarding the victim's medical records in this case. I previously believed that in 2018, the victim had not named another individual as her abuser for the pending charges and argued as such. But then these messages clearly show, then she says, these messages clearly show the victim naming another individual. That is the reason it was not prosecuted. You said it was only because the victim is no longer willing to go forward. That may have been one reason, but you clearly gave me the impression, or wanted to give me the impression, that the victim being unwilling to go forward was the only reason it was non-pros. And that's clearly not accurate.
Your Honor, my understanding
I'm
is
looking
that.
right at it. I don't know why you pointed me to it.
Your Honor, my understanding, and this was discussed in front of the district court with the motion to dismiss hearing. Judge Giles read this the same way I read it, which is that the null pros was because of the victim's desire to no longer go forward with the case.
Okay.
So I didn't certainly mean to mislead, Your Honor. It's what I believe is accurate and is how I interpret this. I think the first part of that is her trying to let the court know about something that she doesn't certainly want the judge to have a misimpression of something she said earlier in the case. But the null process has to do with the victim's desire to not move forward with it. And if you look at the early conversations between the Assistant Commonwealth's Attorney Lauren Pomerantz, who was the initial prosecutor on the case, ACA Elena Lowe only came into the case in January of 2021. So the initial prosecutor in the case was Assistant Commonwealth's Attorney Lauren Pomerantz. And that's something that may not be clear to the court, but that is what is true, and it is also in the documents that are attached.
Let's go back to the time that the officer got the arrest warrant and the information that she had. Maybe you could just lay that out. That made it reasonable that she did that.
Absolutely. So, Your Honor, she went forward with the warrant for arrest and asked for the warrants based on May 5, she has a statement, there's a sworn statement, that the victim has disclosed to the affiant, which was true, that while she was between the ages of 10 and 11, and that's a subset of what is in Alfaro's report. Alfaro's report says 8 and 12. Between ages of 10 and 11, the suspect identified as John Scott Moretti put his penis in her mouth. During the incident, Jane Doe stated that she did not want to and told Mr. Moretti that she could tell her parents and it would stop. Suspect retrieved a handgun, put the gun to her head, told her how easy it would be to pull the trigger and kill her and her family. Afterwards, she complied and the suspect put his penis inside her mouth. During a search warrant of the suspect's residence, multiple firearms were observed. These acts occurred within Prince William County. Those are all true statements and they supply probable cause. So this criminal complaint was a true statement, and there are no lies here that she's made to try to obtain falsely.
And they're arguing that the omissions are the problem, that
Yes.
she omitted that it was, that the victim had reported that it was a family friend. What's your response to that?
Your Honor, my response to that is that they have not alleged facts that are plausible on their face. If you look at paragraph 93 of their amended complaint, it has a laundry list of items that they have alleged should have been brought forward. We have to look at what's actual knowledge in her possession at the time she went to the magistrate, so May 5, what she actually knew. And Detective Alfaro's report, certainly there's evidence that she had an opportunity to read and reflect on and see Detective Alfaro's report, which said a statement that was attributed to her by a referral that she said it was the father's friend, not her friend's father, which is an unusual word reversal if you think about it, because in this case she was close friends with her friend. This man was her father's friend, so it's a unique word reversal, which is confusing, but perhaps there's a game of telephone here because these are statements attributed to her in 2018. In any event, her statement to the police when she's actually brought in and interviewed was, "I don't want to discuss this, and nobody's living in my home that was the abuser." So what you have, if you read together what is alleged to be in her knowledge and insert that into the criminal complaint, then the question becomes, does that negate probable cause? Is the fact that somebody said that she said to a chat hotline in 2018 that her father's friend had sexually abused her between the ages of 8 and 12, if you were to add that to this probable cause statement, JA 78, do we negate probable cause? And I'm going to say no, because they both could be true. It could be true that her father's friend abused her between the ages of 8 and 12. That could be true. And it also could be true that John Scott Moretti forcibly sodomized her at gunpoint. Those are different statements. One does not negate the other. And there could be more than one abuser in her life. As the court well knows, it is not uncommon that a child may have more than one abuser in her life. But clearly she states John Scott Moretti was her abuser in this 5-hour interview very clearly to the detective.
Can we talk about the interview? I think that, I found the procedure followed in the interview deeply disturbing, at least as alleged in the complaint. The fact that it was 5 hours, an interview with a child victim, the actions of the therapist were shocking during the interview. And the suggestion that the victim was forced to sort of make a statement about who abused her and forced to do that if she were to be able to end the interview, which sounds in and of itself rather abusive. And so I guess I question whether relying on those statements was reasonable in and of itself.
Thank you, Your Honor. I would say yes, it was reasonable to rely on those statements. It was very clear in her statement during that 5-hour interview, she very clearly identified John Scott Moretti as her abuser. It took her a while to get there. That's not uncommon, that child abuse victims, child sexual abuse
Is it
victims
common to interview a victim for 5 hours?
I don't know that that is an inappropriate amount of time. I don't know that the court has ever put a specific amount of time on how long a child interview can be conducted. So I understand the question Your Honor is raising. I think that is something to be explored at a trial. That is information that they could talk about in front of a jury and try to impeach her statement, for example. That's a credibility issue that would be resolved in front of a trial. It is not something that would be discussed in front of a magistrate when you're asking for a probable cause warrant. And there's no precedent that I'm aware of in the circuit that says that she has to talk about exculpatory material the way you're describing. If you look at Coakley, I would suggest to this court, Coakley is very much on point with this case. And it specifically says in Coakley that the officer is not expected to come in and provide every piece of information, every fact of her investigation to the magistrate. It's not reasonable, it's not practical, it's not what the Constitution requires. Exculpatory information, what you're describing, Your Honor, when you talk about the details of the Moretti disclosure in the 5-hour interview, that's something that would be discussed at trial, but it's not something that this court, this Fourth Circuit, has ever required to be contained in a probable cause statement given to a magistrate. I'll also
Well, if it was plausible and you're saying it should have gone to a jury, then why was 12b-6 appropriate?
I'm sorry, Your Honor. I mean jury meaning when the person was charged.
You said repeatedly that these were facts that would be appropriate to go to a jury, an argument that should go to a jury.
I mean a criminal jury. I mean, if this case had moved forward and not been null pros, those were issues that would be explored in front of a criminal jury if this person had stood trial. That's what I'm saying. In state court, I'm not talking about the 12b-6. 12b-6 was appropriate. I'm sorry if that was confusing. I apologize.
Was the magistrate told that that there was no child sexual abuse material located in the search of all of the cameras and things and computers?
I don't know the answer to that, Your Honor. What is on the affidavit does not include that. So I don't know specifically if she verbally discussed that with the magistrate or not, but I know that it's not.
But it was not on the affidavit?
It's not on the affidavit. I will concede it's not on the affidavit.
Why isn't that an important omission? Because it would have corroborated, if it had been accurate, if they'd found something, it would have corroborated the victim. They didn't find anything, so it didn't corroborate the victim.
Well, the absence of evidence, I want to suggest to the court, is not something that would have been needed to be discussed with the magistrate. And it's not really surprising.
Except that in the officer's experience, these sorts of perpetrators hoard child sexual abuse material. It's very unusual not to find something.
So, Your Honor, I would tell the court that in this record, we know that this detective contacted him on November 7, and then on November 11, there was a search warrant of his home. So
And by him, you mean appellant?
Yes.
And so you're suggesting that there were 4 days in
Yes.
which the computers and things could have been wiped?
Yes.
Was there any forensic analysis done of those? Because, I mean, you generally can't just delete everything forever. You can find some remnants usually.
Sure. So there was a forensic analysis that was attempted in this case, that is true. And nothing, according to what's in this record, nothing of value was found in the forensic analysis of those.
And usually in the forensic analysis, if there have been deletions made or programs run to get rid of things, you can tell that too. Was any of that, did any of that appear?
I don't know the details of the forensic analysis, Your Honor, I'm sorry, but I will tell you.
And neither does the magistrate judge, because it was omitted from the affidavit.
It's not in the affidavit. I will tell Your Honor that there was, like you said, From November 7, by being contacted, to November 11, when they went to the house, there was time in advance that he would have known that the police were.
I mean, it could have just gotten rid of the computers
Yes.
altogether.
True.
That could have happened.
He also worked for the State Department, and a search warrant was done at his home. It was not done at his office. There's no evidence of that. It wasn't done in other places where he had access to. And so the fact that they didn't find any images of this child, when she said it happened many years ago, right? Many years ago. It didn't happen close in time to the disclosure. And as the court knows, delayed disclosures are not uncommon in child sex abuse cases. The fact that they did not find images of this child does not mean it didn't happen, does not mean that he didn't take these images of her, or that he didn't have them at some point. So I appreciate the question, Your Honor, but again, if you look at what's contained on the probable cause statement that was given on May 5, 2020 by Detective Thorsauter, it does state probable cause, and she went forward and presented this probable cause properly. There is no plausible allegation here that she had the requisite intent to commit a violation of his constitutional rights. She did not have the intent to mislead the magistrate, Your Honor. And it's not plausibly alleged here that she had the intent to mislead the magistrate. She consulted multiple times with her first sergeant. She consulted multiple times with the Assistant Commonwealth's Attorney, Lauren Pomerantz. I'm sorry, Your Honor, I see that my time is up.
You finish your thought there.
She consulted multiple times with the Assistant Commonwealth's Attorney, Lauren Pomerantz, and so she had these conversations with them on multiple occasions and conducted a 7-month investigation before she obtained the felony warrants, which she had a probable cause to obtain. And her actions were proper based on Torchinsky and Coakley. We ask this court to affirm the ruling of the district court. Thank you so much.
Thank you very much. Mr. Migan, Hubbard, you've got some rebuttal time.
Thank you, Your Honor. Judge Thacker, we read JA 88 the same way you do, and we ask for nothing more than the ability to depose the ACA Lowe and ask her what her intent was in writing that letter to the court. But we also think it indicates that there was more withheld than even we thought, in that she indicates that she was never aware that there was an alternative ID made in 2018. And we know that the detective was aware that at least there was somebody identified as the father's friend that would undercut the identification. Someone reading JA 78, the affidavit attached to the search warrant, would be under, would absolutely be justified in thinking that a young woman age 18 walked into the police precinct, testified that she had been abused by my client, that they conducted a search warrant and found a gun. But that's not what happened here. There was a 7-month investigation. There were forensic searches of computers. Nothing except for the fact that, like nearly half of all Virginians, my client owns a firearm, was found to corroborate the identification made by a minor. Even reading the affidavit, you would think this was an adult who walked in and made these allegations, because it identifies the victim as 18, which is true on the day the warrant was asked for, not true at the time she made the allegations. And like you said, Judge Berner, we have serious questions about that interrogation. It was 5 hours long. The therapist played an unduly coercive role in it, and the victim was told she could only end this 5-hour abusive ordeal if she named an abuser. And so, in desperation, we believe, she named my client. She was looking for a way out. She didn't want to destroy her family by saying it's my father's best friend. And so our theory of the case is she picked someone convenient, and that just happened to be my client. Now, yes, it's true, Detective Thorsauter did consult with First Sergeant Tyrell. And First Sergeant Tyrell said, you don't got it. That's JAs 53 and 54, the email where she lays out 7 separate investigatory steps for the detective to pursue. And she even concludes that letter by saying, we have to go out with the idea that it may not be Mr. Moretti, because she said, I have problems with this interview. She's another reasonable officer, and that is what distinguishes this from Torchinsky, is that in Torchinsky, the supervisor corroborated the detective's judgment that he had probable cause. Here, she undercut it. She said, I don't think you have probable cause even for a search warrant, let alone an arrest. And while technically those are the same standards, we know that judges are probably a little easier on search warrants. I see I'm out of time. We would ask you to reverse and remand so that we can go to discovery in this matter, unless you have further questions.
I just have one more question. Your friend suggested that you would need to prove intent to mislead in order to prevail. Is that, do you agree with that?
No, Your Honor, we don't. We think the case law shows that the mere failure the omission or inclusion of evidence that it was false or misleading with reckless disregard of whether or not it would be false and misleading, that's the standard here. There is a reckless disregard standard in cases like Miller, in cases like Clipper versus Tacoma Park. So it's enough to say that she acted with reckless disregard as to whether or not, but also we would argue that the mere fact of searching for a warrant without probable cause, that would be evidence of malice. And the fact that they've never pursued this new lead they received is also, we think, evidence that they had it out for my client, if that was necessary, but we don't think it is. Thank you.
Thank you very much, sir. We appreciate counsel's work. We'll take the case under advisement. Matter of fact, we'll take all of them under advisement. And Madam Clerk will adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.